call the meeting to order. Is it the pleasure of the committee to take into consideration Bill number 6, an act respecting the Enduring Powers of Attorney Act and Wills Act? All those in favor, please say yea. Yea. Against, nay. Carried. Oh, sorry, yeah, sub. So there's, are there any substitutions? Okay. Minister, do you have any opening remarks?
Sure, I'll be brief. This is quite a simple bill we're dealing with here. During COVID, it was clear that people getting together was an issue. Isolation was the order of the day, and that was done for legitimate reasons as it related to dealing with the pandemic, and I must say it was done well in cooperation with the public and those dealing with the public. During that time, there was an inability to meet clients in their homes, nursing homes, places like that. So as a result, the Act was amended in December of 2020 to allow for lawyers, clients, and witnesses to use electronic means as an alternative to in-person meetings when wills and powers of attorney were being signed and witnessed. This was brought in for a 2-year time frame, the intention being that 2 years would be a necessary period of time to cover the pandemic, and hopefully at the end of that time, the issue would have corrected itself. And that is, thankfully, what has happened. Now, although most people have returned to in-person meetings, we've found that still there is an inability of people for disability, in nursing homes, getting out, and things like that, that it still may be desirable to have this type of enabling legislation with respect to execution and witnesses. So the purpose of this act is simply to extend what has been in place since December 2020 and making it permanent. I could argue both cases, both sides, that we could simply let the legislation lapse and return to the original status quo. But in our consultation, it seems to be that this is helpful in many cases. I want to say that I still recommend in-person witnessing and execution. I think that's preferable. I think there's a high duty in the legal profession here, and so there should be. So that being the case, I am open to any questions that the opposition may have. I suspect that the Leader of the Opposition's views on this are probably pretty similar to my own, and I would welcome the questions, and I would welcome his contribution, and we'll see where we go from there. I do feel strongly that if we're not all united on this, I don't feel any great sense as Attorney General that the government should necessarily ram this along. I mean, I think it's something that if we're not all in agreement with doing, well, then that would cause me as Attorney General and Minister of Justice to have some pause and reflection on the matter. So I encourage open discussion, questions, which is what this committee is about. It results in better government, better legislation, and so I'm happy to turn the matter over for questions to my colleague.
Thank you very much. Recognize the member from Moncton Centre.
Thank you, Mr. Chair, and thank you, Minister, for your comments. I don't think we'll be very long today. I think, we agree that it's something that was helpful during the pandemic, and we've seen different areas where, you know, some new normals kind of emerged from the pandemic that we carried on into our lives, you know, in terms of doing things sometimes more virtually and that sort of thing. So in this case, just from reading the bill, I understand that you know, it's not very long. The second page deals with those amendments where you strike out the deadline there of December 31st, 2022. But I'd like to come back to the first page. It looks like it's more of a housekeeping matter, but under the Enduring Powers of Attorney Act, Section 3 is amended by repealing paragraph A and substituting the following. And then you set out, you know, a small, you know, I1, I2. Could you just explain the purpose of that amendment?
As a member opposite, you're quite correct. It is a drafting thing. It's for specification to have it in 2 subsections. It's not any meaningful change. Thank you.
Oh, and that's what I understood as well, just trying to clarify that. So coming to the meat of this, this bill in respect to the execution of wills and powers of attorney, could you explain the procedure? I guess they're two different. They're two different. For a will, where you have your 2 witnesses, and then you'd have I guess a commissioner of oaths that could execute an affidavit of witness. Could you explain the procedure that takes place for signing of a will under these, you know, what this is permitting you to do? I think signing things virtually. Could you explain the procedure? Who would be in what room? You know, who would be virtually, and just the process for the signing of a will?
I guess it comes down to the fact that the situation is virtual. You've got a lawyer, you've got a client, and you've got a witness. All 3 could be virtual. 2 could be present at the same time with 1 virtual. 2 could be virtual and 1 present. So the 3 players here are the lawyer, the witness, and the person executing the instrument. And so this allows any combination of those 3. And if all 3 of them are together at the same time, well then obviously this doesn't apply, and we're back to the original point. So it can be any combination of those 3. Just the same way if we were going to have a virtual meeting, you might be on your computer, me and my colleagues might be in the same room together. All 4 of us could be virtual, 2 of the 4, 1 of the 3, it's just whatever that combination works out. And again, it would be the lawyer who would in large measure drive that agenda. And again, it presupposes a need of the client who either can't get out or can't go. I know that people from nursing homes, you know, going out to middle of winter in elevators and exposing themselves to flu and things like that, that this is helpful in that regard. And so we would look to the profession to conduct themselves the same way they always did, you know, but with this enabling legislation to do it in the 2022 way, which I guess we're all adjusting to. And as you said before, perhaps many of these things would be coming anyway, but COVID had the effect of kind of putting the accelerator down on a lot of this stuff, and it moved the whole virtual aspect of our society, moved forward in steps that I suggest it probably would not have had it not been for a pandemic.
So one item, I guess, would be like the authenticity of the document. And we know that sometimes these estate files can become contentious between family members. How do we assure that, the will that would be signed and that is, subject to, execution of an estate, that it's the authentic document? When we have clients and we're working in person, you get the witness to sign each individual page and then you sign the last page. Is there a process that does the original document get circulated between all parties and there's a final document that has all original signatures on it? Or I guess, how would you assure authenticity of the document at the end of the day?
Each have 3 meetings and pass the document around.
There's a couple of ways to do it, all of which result pretty much in the same thing. And again, I place reliance on the profession. You could have 3 duplicate documents, one signed, one signed, and then together and marked for identification with continuity signatures of the lawyer. That would constitute one document. Or again, just like the virtual meeting, you could have one document which could be executed, or you could have a combination therein. But again, even before this, there was a high duty on the profession with respect to the formalities of executing these kind of documents. The member's father and I were in the same class in law school, and so we took the same course on wills and execution and the duty of the legal profession and the duty and the formalities of the Wills Act. Those things still remain. This is just with respect to execution. And little did I think I would be taking questions from a colleague at law school, son. But anyway, still in the game.
So with that, so if you're piecing all of these documents together, is there a type of certificate that would come with that, I guess, from the lawyer that would certify that those are all the documents that form the will?
Well, again, I would say it's the duty of the profession. It would be almost in the same sense as a notarial certificate, where the lawyer would, given his authority as a notary public, would say, attached hereto to this document is the signature signed by the testator. Next one, notarial. And I think that the legal profession, if they're continuing educations, I'm sure will put together and working with government to have a system of formalities where the individual documents will be assembled as one. I suggest that I would encourage a standard that the practicing bar put with respect to that, marking them for identification, certifying their authenticity, making sure that there is sufficient backup to collectively be able to treat them as one instrument. But again, this is enabling, and it's not the government's job to tell lawyers how to do their job, but there is a standard in the profession to expect a certain level of conduct of the members of that profession, which is what any self-regulating profession would do. So I would see, and I'm going to encourage my staff to reach out and meet with members of the Law Society to really put some work here. I mean, we've got some time. It's in place anyway till the end of the year. It's been working well so far. But I think the point that you raised is an excellent one, and I think that there should be some standards of practice as to how this should be done, and I think it's an excellent point. I'm going to follow up with staff and the Law Society in that regard, and thank you for raising that.
Yeah, thank you. And I guess the same would go with respect to the power of attorney, but there you're just eliminating the necessity to have the two witnesses. You're just the client and the lawyer there that notarizes the power of attorney. So I'm taking that it's the same type of process. You're both virtually. It's either in this case it's one or the other, and if you're both together, then this is not required. So I guess coming back to the Law Society. We've had some time here over the last couple of years to have this in effect. Have you received feedback with respect to either complaints from clients or any feedback from lawyers where there might have been issues that needed to be resolved?
The feedback we have has all been positive, and staff confirms we've had no negative feedback. It is a convenience. It seems to be, all indications are that it's working. There hasn't been any, in the last couple of years, there hasn't been anything that has not been satisfactory. And as I say, without being repetitive, that the feedback has been, the feedback that we've gotten has been exclusively positive.
So coming back to the process here, is there any means of electronic communication that is acceptable? Does it state it in legislation or in regulation that it must be a video communication, or can it be I guess if it's on a telephone, you can't really witness anything. So could you tell us if there's anything in the regulation around what types of communications are acceptable?
Thank you. That question is covered 4.1. It's in the definition. Electronic means of communication is defined. It's a defined term under the statute, and it means an electronic means of communication in which all persons are able to see, hear, and communicate with one another in real time to the same extent as if the persons were communicating in person in the same location. So it by operation of law, it is the exact same as if the three of them were there.
And with that, in these procedures with respect to wills, one of the items, prerequisite is to assess, mental capacity, the capacity to give directions. Is there anything, it might fall more under the scope of the Law Society, and it's the same standard of practice would apply, I imagine, but is there any direction in respect to getting instructions from clients? Can that be taken through these means of telecommunication, or is there guidelines with respect to having those types of meetings in person? What kind of direction is there around that?
You're correct in pointing to the Law Society, but all the standard is still the same. The duty and obligation to make sure that a person is competent to do that all remains the same. This deals only with execution. The duty of a lawyer to make sure that the client, the person executing, is competent to do so, that obligation remains. And the liability for not following that obligation is as high with or without this legislation, as this legislation deals with the execution thereof only, not with any legal obligation on a member of the practicing bar.
Do you anticipate any additional regulations following these amendments?
I don't anticipate any, but in cooperation with the Law Society, there may be some forms of regulations with respect to certification that might come its way, but right now we do not foresee that, and I think it would be fair to spend some time with the Law Society in this regard. It may come to that. It may be just done by standard of acceptable practice of the Law Society, or it may be by regulation, but we do not anticipate any right now, but I wouldn't go so far as to rule any out.
Mr. Chair, those are all my questions. I don't want to belabor the issue here. I think it's good legislation. I appreciate the minister acknowledging that they can do some work with the Law Society, just with respect to checks and balances around, authenticity and that around the documents. And I think he explained it rather well, in terms of putting the documents together and having them marked as exhibits to one another, and with respect to the will. And I think it's something that can be useful moving forward. Oftentimes when we're dealing here, it can be with seniors that want to update their will. They might not be physically well to be mobile, and this can bring people together a lot quicker, faster. Oftentimes lawyers are making emergency runs to houses or hospitals and the like, and so if there's a tool in place that can make that process easier, I think it's worthwhile going down that road. And I think we can talk about just making sure those checks and balances are in place, and I have faith in the Law Society to govern the practice of law and govern these types of procedures to make sure that standards are followed and met by the profession. So thank you very much.
Thank you. Any further questions?
You're very welcome. I want to thank the Leader of the Opposition for his questions, his cooperation, and his contribution to the analysis today.
Thank you. Any further questions on member from Fredericton South, Leader of his party?
Thank you, Mr. Chair. And through you, good afternoon to the Minister and the Deputy and staff. Good to see you again, Deputy. Less exciting times. Well, maybe they are exciting, I don't know. But so this Bill 6 is pretty straightforward. I think the main thing I'm interested in really is, and needed, the main thing I'm interested though is whether there was any work done to check with other provinces who have this ability to use power of attorney electronically in terms of communications, whether they've run into any unanticipated impacts, or not impacts, but challenges or issues. Really, that's the question, which is to see whether that look was taken and whether anything that was learned from there was anticipated or considered in formulating the bill. I don't know, does it get complicated if you've got multiple powers of attorney spread out across the country? Just a question: how has it worked elsewhere, and were those any sort of, was there anything taken away from that in terms of drafting the bill?
Thank you for the question. Most jurisdictions, I think all jurisdictions, did this type of legislation with respect to COVID, as we often do when the decision was made to investigate making this permanent. Associate Deputy Minister, you reached out with the colleagues across the country, got no negative feedback. The definitions are pretty much all the same. The legislation is pretty well identical in the other jurisdictions, and we received no negative feedback whatsoever.
Okay, well, through you, Mr. Speaker, or Chair, to the Minister, I want to thank him for his answer. This is clearly, in my view, needed as well. I'm glad that the actions being taken to make it a permanent feature here in the province of New Brunswick, and certainly support the bill. So thank you for the time.
I'd like to thank the member opposite for his cooperation. Appreciate that.
Thank you very much. Any further questions on Bill 6? Seeing none, Minister, you have any closing remarks or comments, or? No, you're good? Good. All good. All right, we'll just have the staff to step out and we'll do our vote. Is it the pleasure of the committee that Bill number 6, an act respecting the Enduring Powers of Attorney Act and Wills Act, stand as presented, and that I report the bill as agreed to? All those in favor, please say yea. Yea. Against, nay. Carried. We'll take a brief recess and bring in the next department. Call the meeting back to order. Is it the pleasure of the committee to take into consideration Bill number 17, Disclosure to Protect Against Intimate Partner Violence Act? All those in favor, please say yea. Against, nay. Carried. Mr. Minister, do you have any opening remarks?
Thank you, Mr. Chair. Over the last 4 weeks, I've had the privilege of introducing some very good bills into this legislature, and this will certainly be one of them. I'm pleased to introduce this bill because the reality is, Mr. Speaker, that domestic and intimate partner violence continues to be an issue here in New Brunswick and across Canada. Steps have been taken over the years to address the issue, both in terms of services and legislation, but much of the focus has been on addressing the issue after the fact. As important as it is to support victims of intimate partner violence, we need more tools to prevent it. That is why we are introducing the Disclosure to Protect Against Intimate Partner Violence Act. This act will allow individuals to apply for information from the police to find out if their partner has a history of intimate partner violence. This will give those at risk another tool to make informed decisions about their safety and their relationships. The application process also provides another opportunity for violence prevention, and that applicants can be offered and referred to programs and support services. It is important to note that the privacy of the subject of requests is always protected, and applicants will only be provided with a risk assessment and contextual information. No details of criminal convictions or similar types will be provided of that information. This will be done verbally. No documents will be shared, and applicants will be barred from sharing or publishing any information received, and it cannot be used in any legal proceedings. Mr. Chair, we'll continue to explore ways to make New Brunswickers' homes, lives as safe as possible. And with that said, I do want to, we're going to have an introduction here from one of the members of the committee, but I do want to, as a minister, also welcome Colette Martin here from the Miramichi. She's an advocate for what's known as Clare's Bill, which is very similar to what we're introducing, and she's been a strong advocate in regards to trying to mitigate and end domestic violence. So I'm happy to take any questions from the members in relation to this bill. Thank you, Mr. Chair.
Thank you very much, Minister. At this time, I'll recognize the member from Miramichi.
Thank you, Mr. Chair. I too would like to stand and recognize this bill as being an amazing bill brought forward by the minister and his team, and also to recognize my friend Colette in the gallery. Colette's here with us today because she's an advocate, and she's been fighting for, like the minister said, for Clare's Bill for a long time. In 1997, Colette herself was almost murdered by an ex-boyfriend. He smashed the door in the middle of the night, attacked her, slit her throat, and stabbed her 37 times. It took her a long time to start to heal and to finally have a voice, and now she's fighting for everyone that doesn't have a voice, for those that we've lost. She's sharing her story, and she's the voice for many others. And because of it's her strength and her courage that she's here today, and she's saving lives, and this is what this bill is essentially going to do too. It's going to save lives. So I'm very pleased to have my friend Colette here with us today, and to share the magic of the bill going forward, and to see it happen for us. Thank you, Mr. Chair.
Thank you, Colette.
Thank you. I'll go back to the minister, and you can introduce your staff.
Thank you, Mr. Chair. I apologize, but of course, any good bill like this has a team behind it that's been working hard to, get the details of the bill worked out, and to ensure that, what's put in legislation has practical means on the ground to help save lives and again reduce domestic violence. So, to my left is Janet McKenna. She's a senior policy analysis through Justice and Public Safety, who's done a lot of work on this bill, to help answer questions here today as well. And of course, we have Deputy Minister Mike Como here to my right, who also plays a big part in legislation that is being brought forward. So I just wanted to introduce them and thank them and the team for being with me here today and the work that has been done on this bill. Thank you, Mr.
Thank you. Recognize the member from Kent South.
Merci, Monsieur le Président. Écoutez, ce que moi je veux faire, c'est de dire que tout projet de loi qui peut aider à la diminution, à la réduction de la violence conjugale et domestique, évidemment, notre parti est tout à fait pour. Ça, c'est clair. Soyons clairs qu'on veut voir davantage de législation qui va aider à réduire cette forme de violence qui est tout à fait inacceptable et qui, malheureusement, existe encore trop dans notre société. Tout de même, poser beaucoup de questions n'est pas signe que nous sommes contre le projet de loi. On veut simplement, on cherche des clarifications, avoir davantage de détails. On a quelques petites préoccupations et ces préoccupations-là, je répète, c'est dans le but de voir améliorer la situation, parce qu'en bout de ligne, on veut que davantage de femmes et d'hommes, surtout les femmes, puissent bénéficier pleinement de ce projet de loi. Donc, la première question que je veux poser, c'est est-ce qu'il y a eu des consultations avant l'introduction de ce projet de loi? Merci.
Thank you, Member, for that question. So there has been consultations done on this bill. There's been discussions internally within different departments. Women's Equality Branch had, of course, some input and discussions back and forth on this. The New Brunswick Association of Chiefs of Police also were one group that was part of the discussions around this bill. Aboriginal Affairs spoke to it as well, and Finance and Treasury Board.
Merci, Monsieur le Président. Je n'ai pas entendu dans ces consultations-là, est-ce qu'il y a eu des organismes qui sont sur le terrain, des organismes comme le Centre de crise familiale, au séjour que je connais, le Centre de la prévention de la violence de Kent. Ça, c'est les deux que moi je connais, là. Il y en a partout dans la province comme ça, là. Est-ce que ces organismes-là ont été approchés pour des consultations? Parce qu'en bout de compte, ce sont ces organismes-là qui traitent avec les femmes et les hommes qui sont touchés. Donc, je voulais savoir, est-ce que ces gens-là ont été consultés?
Thank you, Mr. Chair. So, again, internally, we're talking about the Women's Equality Branch, which played a key role in the development of this bill. You have the New Brunswick Association Chiefs of Police, which played a role in this bill, Aboriginal Affairs as well. The external organizations, certainly from what we have heard, what I have heard, have been very supportive of this bill. They see this certainly as a step forward to helping women and others, or men for that matter, to be able to dig in a little bit about their partner, especially when they first are developing that relationship. So overall, it's been very positive that we've been hearing from them. In relation to consultations, my department and the team is certainly open to discussing with those folks in terms of regulations of how the bill is implemented in the regulatory process. I'm sure we'll be sitting down with them to get some idea and feedback on seeing how it works in everyday life.
Merci, Monsieur le Président. Ben, écoutez, je dois admettre que ça commence un peu sur un pied un petit peu chambranlant, parce que ce que le ministre a dit, c'est non. Il n'y a pas eu de consultation avec les gens sur le terrain, les gens qui traitent directement avec les victimes. Et juste ça, je t'avouerai, puis là, le ministre réalise qu'il a fait une erreur parce qu'il a patiné, là. Il n'a pas donné la réponse, parce que la réponse, c'est non. Et ça, je trouve ça malheureux. Parce que c'est important, cette législation ici, et le fait de ne pas consulter avec les gens sur le terrain avant même de commencer, ça m'inquiète. Parce qu'on parle que c'est positif, puis on essaie de mettre un spin positif. Je comprends pourquoi, parce que c'est important. Mais si c'est si important que ça, il faut en parler avec les gens qui sont sur le terrain. Moi, je vous avouerai que ça me déboussole. En tout cas, donc, y a-t-il moyen, non, ben, est-ce que je me trompe, là, me semble? En tout cas, y a-t-il moyen que ces gens-là soient consultés d'abord? Parce que c'est une chose, il y a un risque réel ici qu'on est en train de passer un projet de loi qui créerait des nouvelles façons de faire que des règlements ne pourront pas fixer, ne pourront pas régler. Et il faut s'assurer que le projet de loi permette une mise en œuvre, une mise en application du projet, que ces gens-là, que ça va les aider réellement. Parce que quand ce que le ministre dit, qu'il a entendu de façon anecdotique que tout le monde appuie, c'est bien beau. Moi aussi, j'appuie des choses en principe. Mais comme on dit en anglais, là, le diable est dans les détails. Et puis, moi, je veux voir, pour m'assurer que ces gens-là, si on leur met beaucoup plus de demandes, on leur met beaucoup plus de... Tu sais, je donne un exemple. Puis à la fin, ça leur donne beaucoup plus de travail, puis qu'ils n'ont pas les ressources pour le faire, ils n'ont pas le temps. Puis à cause de ça, ça crée plus de problèmes que ça règle des solutions. Et non seulement on n'a rien réglé, on crée encore plus de problèmes. Et la façon d'éviter ça, ben, c'est la consultation. Et puis là, je ne parle pas d'une consultation politique, là, parce que vous savez qu'en politique, parfois on fait des consultations, parfois tu sais, pour toutes sortes de raisons politiques, je ne vais pas élaborer. Mais ici, je parle d'une consultation réelle pour faire avancer la cause des victimes. Parce que ces gens-là savent. Puis je suis convaincu que les gens de la division de l'équité des femmes, puis l'association des chefs de police, puis tout ça, qui veulent la bonne chose. Absolument. Et c'est une bonne chose que le ministère a consulté avec eux. Oui, c'est une bonne chose. C'est une très bonne chose. Mais à la base, ce sont les gens sur le terrain. C'est les Crystal, puis c'est les Linda, que moi, à qui je parle, que jour après jour, ils voient des gens qui arrivent là, avec les yeux au beurre noir, puis avec les bras cassés. Ben, c'est ces gens-là qui ont besoin d'être consultés. Parce que ces gens-là, que jour après jour, ils les voient. Donc, j'aimerais d'entendre le ministre là-dessus, parce que moi, je veux éviter qu'on a créé un projet de loi, puis là, quand le ministre dit, bien, on peut le faire avec les règlements, ils seront consultés. Bien, je veux être sûr que c'est vrai, parce que sinon, on risque de créer une grave erreur. Puis moi, je ne veux pas être associé à cette erreur-là. Je peux vous dire ça. Donc, mon rôle ici, c'est de supplier le ministre et de lui demander de s'assurer que soit il peut me confirmer à 100% que les règlements pourront fixer la chose s'il y a des choses à ajuster, puis que le projet de loi qui s'enligne pour passer ne va pas porter obstacle à ce qu'on veut réellement faire. Merci.
Thank you, Mr. Chair. In relation to consultations, again, the department did a lot of work consulting with the Women's Equality Branch, which is one organization of several that I mentioned that the department has discussed with. Now, if the member opposite doesn't have any faith in the Women's Equality Branch, I guess that's something maybe he can take up with them. But it's my understanding the Women's Equality Branch continues to reach out to different stakeholders on a daily basis, on a weekly basis, to get that information, to ensure that that those stakeholder consultations do take place, even in the regulatory process. You know, at the end of the day, I agree wholeheartely. Consultations are important. That's why consultations were done for this bill. That's why consultations will continue in the future with various organizations to ensure that the regulatory structure that feeds into this bill works with the practicalities on the ground. So, look, at the end of the day, this bill is designed to reduce domestic violence. And, You know, the member opposite mentioned that the devil's in the details. Well, the bill is the details. So if he can point out anything in the bill that he'd like to question on particularly, I'm more than willing to answer in good faith and offer some insight on sections of the bill, and that's what we're here to do. But again, in relation to consultations, there was internal consultations. I listed them. There's going to be more consultations in relation to the regulatory process, which I think is exactly the way this should go. The Women's Equality Branch daily, weekly, reaches out to various organizations around the province to understand what is happening on the ground and to ensure that those issues, that those problems or whatnot is passed up into being part of this bill and other bills that are presented by Justice and Public Safety. So, thank you, Mr. Chair.
Thank you, Mr. Chair. I'll try to play nice, Mr. Chair. But I do take offense with what some of the minister just said. Yeah, of course. Because for him to imply that I don't have faith in the Women's Equality Branch, he might have not listened to the answer that was translated to him, but I did say absolutely it was a good thing for them. But to say that just because of that, I think it's not a good idea to consult with the other organizations that are on the ground, for him to imply that because of that I don't have faith in them, that is truly misconstrued and disingenuous. And if the minister wants to play that game, I can come up with a lot of other things. So I do want to caution the minister with that type of language, with those types of answers, because this is, I'm coming here in good faith to try to improve the bill, but I will not let myself be insulted, and this will not go well for him and for this bill. And I'm hoping and I'm calling for a constructive conversation from this minister, which I am more than willing to do, and I will, but the minister has been warned. I'll leave it at that. La prochaine question, c'est est-ce que... Ben, il a plus ou moins répondu à ma question par rapport à la question de que ça va être fait. Je vais répéter la question. Est-ce que la consultation qu'il compte faire avec ces organismes-là, les organismes sur le terrain qui traitent avec les victimes, est-ce qu'ils vont, à eux seuls, la réglementation qui se fait après le projet de loi, est-ce que ça va régler l'ensemble? Est-ce que le projet de loi va mettre des contraintes? Là, je parle lentement pour m'assurer que la traduction se fasse bien. Est-ce que ce projet de loi-là va mettre des contraintes qui seront obligés de revenir sur leurs pas pour faire des modifications à la loi, pour s'assurer que, oups, on a peut-être été trop loin, puis là, quand on a consulté, on a réalisé que ce n'était pas tout à fait la bonne démarche, on aurait dû le faire différemment. Moi, je veux éviter ça. Donc, c'est pour ça que la question de la consultation est importante. Parce que nous, comme législateurs, on a le rôle de s'assurer qu'on a la bonne législation. Parce que, je vais être compris, là, on veut absolument que ça marche, ce projet de loi ici. Donc, j'en reviens à la même question, puis j'espère avoir une réponse un peu plus claire. Merci.
Thank you, Mr. Chair. That was quite interesting framework there that was teed off. So the whole purpose of these committees is that government introduces a bill. Obviously, the Department of Justice and Public Safety, the Attorney General's office looks at the legal aspect of it. Different stakeholders look at different aspects of it. We present a bill. It comes to committee, and this is where we discuss the bill. Now, what happens from here on out, hypothetically, well, again, that's to be determined. We're confident in the bill. We're confident that the regulatory process will be a part of this bill, and that this bill will not have to be amended to accommodate that regulatory process, but part of this process is just that. If there is an angle that can improve the bill in terms of the regulatory process, then, again, that's part of the committee work. So I'm not sure exactly what the question is in relation to this bill, but if maybe the member wants to ask again or frame it differently.
Je vais poser la question encore une fois parce que je trouve que la question est très importante et le ministre semble avoir de la difficulté à comprendre la question. J'espère que c'est ça. On s'enligne tout de suite à passer un projet de loi. Puis, écoutez, le gouvernement est majoritaire, là. Le projet de loi va passer éventuellement. On s'enligne pour passer un projet de loi où les gens du terrain n'ont pas été consultés. On vient de le déterminer, là. C'est une chose faite. Bon, OK. Puis là, le ministre nous dit, quand ça va venir à la réglementation, ils seront consultés, puis on va s'assurer que la réglementation soit faite de façon appropriée. J'ai tout compris ça jusqu'à cette heure. C'est ça que j'ai compris de la réponse du ministre. Ma question est, en passant le projet de loi tel qu'il est en ce moment, là, comme je l'ai dans les mains, est-ce que ça va faire en sorte que la réglementation sera un peu trop contrainte, que même si on les consulte, ces gens-là sur le terrain qui traitent avec les victimes, ils vont leur dire « Ah, bien, il faudrait le faire d'une telle façon, d'une telle façon. » Puis là, la réponse du ministère, parce que le projet de loi a passé, ça va être de dire « Ah, ben non, on ne peut pas le faire comme ça parce que la loi ne le permet pas. » Je ne sais pas si vous saisissez, là. En d'autres mots, est-ce qu'en passant la loi telle qu'elle est écrite, comme que vous l'avez écrite, comme vous l'avez rédigée sous votre supervision, Monsieur le ministre, est-ce que ça va empêcher des modifications que les gens pourraient demander, qui pourraient améliorer la demande? Parce que, comme je vous dis, c'est eux qui sont sur le terrain, c'est eux avec qui c'est important. Voilà ma question. Est-ce que la loi va empêcher la modification des règlements, ou puis si la réponse est du ministre est de dire « Nous sommes confiants que la façon que le projet de loi va passer, qu'il y a suffisamment de latitude, il y a suffisamment de flexibilité pour que ces règlements-là puissent être ajustés selon la demande, bien moi, je serai content avec cette réponse. Là, c'est la troisième fois que je demande la réponse, puis là, les deux premières, j'ai eu aucune réponse. Donc, j'espère que c'est plus clair, et puis, comme je vous dis, ceci, c'est pour le mieux là, du projet, selon moi. Merci.
Thank you, Mr. Chair. So, again, I would not sign off on a bill if I didn't think this bill was a good bill. And I'm convinced that this legislation will enable individuals in relationships or starting to get into relationships to be able to have some input, or not input, but information in relation to the relationships they're getting into. Other jurisdictions have done this, known as Clare's Law in other parts of the world. We have done a jurisdictional scan in other provinces as well to ensure that we're lining up with other areas. But like any legislation, I mean, the whole reason we come here as MLAs and legislators is to pass legislation. If every bill that was ever passed was absolutely perfect and flawless, none of us would need to be here. So the whole point is we pass what I believe is excellent legislation. If in 6 months or 6 years, you know, society changes in some way, or you know, things happen, well, again, we're all paid as MLAs to be here to amend bills, to craft new bills, to bring in new legislation, to do what's necessary to ensure that our laws match our society and protect our society. So, you know, I mean, I don't know if, again, I'm confident this is a good bill. I stand by this bill. But if there is a time down the road that it needs to be amended, again, to adapt to society, to ensure that domestic relationships, women and some men, have the best protection possible through the law, then we will amend it and make changes. But I don't know what else to say. That's the way these things work.
Bon, ben au moins, j'ai eu une demi-réponse. Et puis, c'est pas la réponse que j'espérais d'obtenir, mais au moins, j'en ai eu une. Le ministre dit que c'est le travail du législateur d'être ici, puis on est payé pour passer des lois. C'est tout à fait vrai. Mais c'est justement le travail, c'est de l'avoir comme il faut la première fois. Pas de venir et revenir, puis d'en faire un essai et erreur. Donc, si on veut éviter le essai et erreur, on consulte avec les gens avec qui c'est important, parce que les gens qui sont sur le terrain. Donc, et c'est là où je t'avouerai que je suis déçu, je vais le dire comme je le pense, je suis déçu du fait que ces gens-là n'ont pas été consultés. J'espère. Le ministre a confiance. Évidemment, il a confiance parce qu'il est là. Ils ont signé, ça a passé au cabinet. Mais le fait que ces gens-là n'ont pas été consultés, moi, comme je vous dis, le principe, il n'y a personne ici, je ne peux pas voir qu'il n'y ait aucun des 49 députés, moi le premier, qui va opposer une législation qui va améliorer ou qui va améliorer pour éviter qu'il y ait d'autres victimes, qu'il y ait davantage de victimes. C'est clair, clair, clair. Mais la question est, c'est dans l'opérationnalisation de la chose. Et puis, ouais, c'est là où je trouve que, en apparence, puis j'ai peut-être mal compris, mais en apparence, selon les réponses que je reçois de ce ministre, je pense qu'il aurait pu avoir davantage de consultations, surtout avec les gens sur le terrain. Bon, OK, je pense que j'ai fait assez de... Je pense que mon point a passé. On va continuer. Le ministre a fait référence avec ce qu'on appelle ça, la loi de Clare. Je vous avouerai que moi, je ne suis pas familier avec cette loi-là. Est-ce que... Et puis, la prochaine question, c'était est-ce qu'il y a des lois similaires dans d'autres juridictions? Le ministre a donné un peu une réponse à ça en disant que oui, on s'enligne avec d'autres juridictions. Est-ce que le ministre peut m'expliquer c'est quoi la loi de Clare, numéro 1, puis numéro 2? Où cette loi-là existe? Comment... Est-ce que ceci, c'est la loi de Clare, ou est-ce que ceci est quelque chose comme la loi de Clare? Est-ce qu'il faut avoir une autre loi qui est la loi de Clare? En tout cas, j'aimerais avoir des précisions par rapport à cette loi-là, par rapport à la loi de Clare, et aussi par rapport à d'autres juridictions, on va dire, canadiennes. Merci beaucoup.
Thank you, Mr. Chair. So, Clare's Law was introduced in the UK several years ago. There was a tragedy that happened in that part of the world where an individual by the name of Clare was killed by her partner through domestic violence. So the UK had started a pilot project to introduce some policy changes to now allow for intimate partners to be able to ask about their partner in relation to any background in domestic violence and anything that would relate to that. So what we've done is we've basically taken that concept and we've brought it here to New Brunswick and kind of fitted it to what we see here in New Brunswick with the same sort of root system or the same idea as we saw in the UK. We are not alone. Here in Canada, when it comes to this type of legislation, Saskatchewan and Alberta both have legislation very similar to what we're introducing today. Newfoundland did introduce legislation, but it has yet to receive royal assent, I think, since 2019. And Manitoba actually just a few weeks ago received royal assent on a very similar bill to what we're introducing today. So we're not reinventing the wheel here. The premise does come out of the United Kingdom in relation to the incident that took place there, the tragedy. And the whole idea behind it is to give women the tools they need to protect themselves. And that started out of the UK, and it's spread around the world, as we're seeing. And here in Canada, we're not unique to this. As I mentioned, there's several provinces that currently have that legislation, and we're following suit by bringing this forward here today. Thank you, Mr. Chair.
Merci beaucoup, Monsieur le Président. Ben voilà, là j'ai eu une réponse pleine et entière pour ma réponse, puis je remercie le ministre pour cette réponse claire et qui nous donne une bonne idée de la situation. Merci. Ma prochaine question, ça serait à savoir quel est le seuil, le threshold, comme on dit en anglais, à partir duquel on peut faire une demande pour savoir si un partenaire a des antécédents de violence conjugale. En d'autres mots, est-ce que c'est n'importe qui peut le faire tout le temps ou est-ce qu'il y a un seuil? C'est ça la question. Merci.
Okay, thank you, Mr. Chair. Thank you for the question to the member opposite. Yeah, so there is a threshold there. What we don't want to see happen with this bill is, these fishing expeditions where, we're trying to get information that's not relevant in a specific situation in terms of the relationship the individual's in. So there will be an application process that the individual will have to submit to law enforcement. Law enforcement then will vet that to ensure that indeed the individual is finding themselves in a relationship at that point and is seeking input or information that is solely in relation to domestic violence. So again, the bill is tight in that sense. It's not wide-reaching, but it's zeroed in on the issue around domestic violence. So there is a process that is going to have to unfold there, that law enforcement is going to have to go through with the individual that's seeking this information, and there will be a filtering and a vetting process for that to ensure that, again, it's not just someone going on some expedition, about someone else's information that they're not intimately tied to.
Thank you to the Minister through the Chair for that answer. I guess my next question, that's good. I mean, that's a fair answer. I think that makes a lot of sense. I guess I heard the Minister in his preamble talk about the fact that the answers won't be written. It'll be oral. Now, does the request need to be oral as well, or does that need to be written? And is there any chance that that could be traced, I guess, is also, because it's one thing to have an answer, but if you have to do a request and you have the same issue, then I'm not sure, you know, you understand why I'm raising the question. I'm just hoping you've thought about it and there's an answer for that. Thank you.
Okay, thank you, Mr. Chair, and thank you, member, for the question on that. So, yeah, as I said, there's going to be an application process that will come through the department, and then the department will work with law enforcement again to vet those applications to ensure that they are legitimate. So, once a legitimate inquiry has been made, at that point, law enforcement would sit down with the individual who made the application and basically give that individual a risk assessment. You know, how the risk assessment would unfold, again, as part of the regulatory process, but there would be verbal acknowledgement to the person who made that inquiry. You know, here's your risk assessment, whether it's medium, high, low, and some of the information around that. Again, will be worked out in the regulatory process, but it will be a verbal discussion with the person who made the application. So then that individual then has the information. They know, at least to some extent, you know, where they're at in their relationship and what the individual may or may not bring to that relationship that may be detrimental or toxic. So that's the breakdown of how that would work. And again, some of the details of the risk assessment would be part of the regulatory process.
Thank you, through the Chair, to the Minister for that. I'm not sure I got an answer with my question, because the Minister reiterated what he said in his preamble about the risk assessment, which is the end, which you know, once the application has been reviewed. I'm talking about the before, when you apply. Do you apply? You know, is it a written application? I'm guessing it is, because if it's vetted, then there's probably some type of written, you know, something written somewhere for somebody to vet, because I don't think it's being vetted, you know, orally in front of somebody who just, you know, automatically assesses it. But maybe I'm wrong, but that's my impression. So my question is, it's not about once it's vetted, it's before it's vetted. Is it written? And is there any chance that that could leak? Or that's where my fear is here. I hope you understand the question. Thank you.
Well, as I said earlier, it is an application, so yes, it's going to be written. Now, to the member's question in relation to privacy, it's going to be held in the same privacy laws that any other document's going to be held in. You know, government, law enforcement, take these things seriously in terms of the written application itself. But yes, there is an application process, and that would be written.
Merci, Monsieur le Président. Non, c'est beau, ça répond à la question. Je voulais juste vérifier. Une fois que l'évaluation va être donnée, je voudrais savoir quel type d'informations seront données. Bon, le ministre a fait allusion que ce sera si le risque est haut, ou il est bas, ou il est moyen, ainsi de suite. Puis ça demeure à être précisé. Mais est-ce qu'il y a des informations telles que des condamnations pénales ou des rapports de police ou de plaintes? Est-ce que ce serait des exemples de choses qui pourraient être divulguées à la personne qui en fait la demande? Merci.
Yeah, okay, so thank you for that question. So any type of legislation like this, you have the Fine Balancing Act to protecting, obviously, the person making the inquiry or filling out the application to ensure they get the information necessary to have more information on their relationship and the potential for again, domestic violence or problems in that regard. The other side of that is ensuring that you know, there is a certain level of privacy for individuals. So this bill would not allow the disclosure of particular information. So, you know, this isn't an issue where you fill out an application and you can find out someone's, you know, convictions or charges or a long laundry list of warnings and whatnot. That's not the intent of this bill. But what it will do is it will enable law enforcement, again, to sit down with the individual and say, look, you know, there is a significant risk that this individual does pose that you need to be aware of, or you know, there's no evidence of that. And again, how that breaks down and how that risk assessment is done will be part of the regulatory process, but it will be verbal because, again, we have to make sure we strike that balance to ensure that people are protected, they have the tools they need to have the information about the individual they're in a relationship with, but at the same time to protect the privacy of the individuals that's being requested of.
Merci, Monsieur le Président. En fait, à travers vous, au ministre. OK, ben ça répond bien à la question, puis c'est un justificatif qui se tient. Donc, ma prochaine question, à savoir, quelles sont les sources d'informations qui seront utilisées par la police? Est-ce qu'on parle du centre d'information de la police canadienne? Est-ce qu'il y a d'autres sources d'informations qui seront utilisées par la police pour faire ces déterminations? Le ministre a bien expliqué, selon où on en est, de comment ça sera transmis à la personne. Mais ma question, c'est quelles sont les sources d'informations dont la police va disposer pour recueillir les informations recherchées? Merci.
Thank you, Mr. Chair, and thank you, Member. That indeed a good question. So the information is vital. Of course, that's what this whole thing is about. So when an applicant would go, when someone would fill out the application and they would be recognized as a legitimate individual seeking this information, there's various points where information would be taken. Of course, it'd be the municipal police force or the RCMP. We also have what's known as the Justice Information System provincially. So anything that would relate to any police engagement, you know, maybe not a large scale, but maybe somewhat of a minor scale, would be found in that information, which is interconnected among municipal police forces. But then we also have the Canadian database, the police database. So that's a federal database where the more serious charges would be found. And so basically the information would go right from the local level all the way up to the federal level. So there's different avenues where that information would be obtained. And then that would give the local law enforcement a better grasp of the type of risk that the individual who applied may be facing or may not be facing, to be able to direct them accordingly.
Merci au ministre via le président pour cette réponse. La réponse est claire, je l'apprécie. Ma prochaine question, et c'est un petit peu délicat, puis ça, je pense que c'est une question importante. Est-ce que la personne qui est ciblée, pas la personne qui fait la demande, mais la personne qui est ciblée dans la demande, est-ce que cette personne-là va être notifiée? Est-ce que c'est une enquête confidentielle? Est-ce qu'il y a une enquête qui va se faire avec la personne et que cette personne-là va être questionnée? Ou est-ce que c'est quelque chose qui est complètement sous le radar, si je peux le dire comme ça, pour maintenir une certaine confidentialité? Que je pourrais comprendre, mais c'est ça, j'essaie juste de comprendre. C'est juste à savoir comment tout ça va marcher. Merci.
Okay, thank you, Mr. Chair. So I guess the direct answer is no. The information in relation to the individual that's in question through the application process, once the application is completed, again, law enforcement, the department has determined this is a legitimate application. Once that process has started, at that point, whatever information is sought on the individual, no. That individual would not be made aware that process is ongoing towards them or the information in relation of their background. And for obvious reasons, of course, we want to make sure that we protect the applicant from any retribution should the individual find out. So, thank you.
Merci au ministre via le président pour cette réponse. Et puis oui, non, je pense que ça a du sens. Je voulais simplement le clarifier. Merci, voilà. Prochaine question. Je crois comprendre qu'au Nouveau-Brunswick, la police n'a pas le pouvoir d'approuver une accusation. Donc, pouvez-vous confirmer que c'est le cas et que l'approbation des accusations est la prérogative du bureau du procureur de la Couronne? Je pose la question parce que là, on dirait que le projet de loi pourrait un peu jouer là-dedans, là. Donc, je veux juste m'assurer que, d'abord, est-ce que on peut faire quelque chose que tout d'un coup, on n'est pas censé de faire, là? Je cherche juste une précision. Donc, est-ce que tout ce qui est une question d'une accusation, est-ce que c'est la prérogative du bureau du procureur de la Couronne ou la police? Est-ce que vous pourriez m'éclairer là-dessus? Merci.
Okay, thank you, Mr. Chair. So, anytime suspected criminal activity is taking place, the police obviously will investigate. If the evidence is there and they feel they have a case, they would recommend a charge, but ultimately it'd be up to the Crown Prosecutor to determine whether charges would go forward or not. So this bill really has no bearing on that, one way or the other. The two are basically separate. The only thing I would say is in the process of filling out an application or going through the application process, if there was criminal activity, within that realm, which would be rare, but if it was, it would give the police opportunity to investigate. But in relation to criminal charges, again, the system is the way it is now for reasonable, understandable reasons. Police recommend a charge. Crown Prosecutor decides whether to proceed or not. This bill has really no bearing on that. Thank you.
Merci, Monsieur le Président. Bon, ça confirme ce qu'on pensait. Il y a une raison pourquoi j'ai posé la question. Parce que dans l'évaluation qui sera donnée à la personne qui la demande concernant l'individu, Est-ce que, parce que là, c'est la question, est-ce qu'il y a eu une accusation, une charge ou pas une charge, est pertinente. Parce que, est-ce que la police aura le droit de dire que la personne a été investiguée ou qu'il y a eu des plaintes? Mais si ce sont des plaintes non fondées ou une enquête qui a été bâclée, vous comprenez comment délicat ça peut être. En d'autres mots, peut-être que la personne a été investiguée 7 fois, mais que les 7 fois, ça s'est avéré non fondé. La personne a peut-être été enquêtée une fois, puis elle a été chargée. Le point que je veux faire, c'est est-ce que les investigations qui s'avèrent où il n'y a pas eu de charge seront déterminées, seront incluses dans l'évaluation? Parce que c'est là où ça... Si c'est la police qui s'en occupe, ben, est-ce qu'ils auront la discrétion d'inclure ça ou non? Ou est-ce que le projet de loi est clair qu'on va seulement parler de charge? J'espère que vous comprenez la question. Merci.
Thank you, Mr. Chair. Again, good question. So the idea behind the bill is to enable the applicant to have a general understanding of the relationship they're in relation to potential future domestic violence. So in assessing the risk that law enforcement would have to do, it's going to be broad. So it's going to include charges, convictions, possible warnings. You know, in a lot of the domestic violence cases that go on, the aggressor in those cases are often repeat offenders. But I do want to emphasize that with that assessment that is broad, the details of the information is not disclosed to the applicant. I want to say that again. So it's for law enforcement to be able to sit down with an applicant and say, look, and again, how that is going to unfold in terms of risk assessment, but to be able to relay the information to the applicant. You know, you are at risk. To give them the information, or look, from what we know of the individual, there is no risk or low risk, but it's not to give the information. The detailed information is not there to give. But the assessment to get to a point of assessment is going to be broad to get all the information. Thank you, Mr. Chair.
Merci. Thank you to the chair or to the minister through the chair. I appreciate the answer. It was a very fine answer. It does, though. The answer, I'm just afraid that it opens the door to potential, and that's not what I want, but I'm just kind of through that answer, I'm just hoping that it won't open a door where police may do some type of assessments, give a certain opinion on something where it hasn't been corroborated by the Crown Prosecutor or anything, you know, that it's just based on other things, and that opens a door which can go places where we might not want it to go. I don't know if there's safeguards regarding what I just said. I hope I'm realizing what I'm saying might not be 100% clear, but I'm hoping you get the gist of what I'm trying to say. So there's that. I'm just throwing it out there. If the minister wants to comment, he's more than welcome to. I am going to ask another question right now. Will the minister have anything to do with access to information? Will the minister have access to this information? Thank you.
Thank you, Mr. Chair, and thank you for the question. So in relation to the information that I would have access to as a minister, I guess the simple answer is no. And I know the member opposite has been a minister in the past, and you look after a lot in your department, a lot of moving parts, you have a lot of overall arching responsibilities, but as far as the fine details of every file and on every individual, no. That's not something I would be privy to as a minister. And I would like to further that by saying the important part of this is like any other government department that works on files with individuals is privacy is important. So the only individuals that would be looking at the information relating to someone who's part of this process, it would be tight. It would be the individuals implementing the program that would have that information. It wouldn't be myself as a minister or anybody else in the department per se, just the program, the people that implement the program would be the only ones that would have access to that information. Thank you.
Merci beaucoup au ministre via le président. C'est la réponse à laquelle je m'attendais. J'apprécie juste une confirmation. Je vais demander une confirmation également. Le ministre vient de nous dire qu'en principe, étant donné la nature très confidentielle des informations, le ministère... La question que je pose, puis si vous voulez juste hocher la tête, ça serait tout ce que j'ai de besoin, puis je pourrais continuer. Mais est-ce que je comprends qu'il n'y aura pas d'autres employés du ministère qui auront accès à ces informations? Est-ce que c'est le cas? Si c'est le cas, vous pouvez simplement faire comme ça, là, puis là, moi, je pourrais continuer. Ouais, ouais, mais je pense que le ministre veut répondre. Il peut répondre. Allez-y.
Well, I want to make sure the information is accurate, because again, just to reiterate it, you are correct. So this isn't something where any employee of Justice and Public Safety can say, I'd like to see the file on John Smith as it relates to this bill. This is going to be very tight, so the only ones that would have access to this information would be the individuals that are actually implementing the program. And of course, they're bound by confidentiality rules, security of the information, databases, all of that sort of thing. So to answer your question, no one outside of that program would have access to that information. Thank you.
Merci beaucoup au ministre d'avoir clarifié cela. Je pense que c'est juste important de le clarifier pour qu'on comprenne comment ça marche. Puis j'ai confiance en la réponse du ministre, j'ai confiance en ce ministère par rapport à ça. C'est clarifié, merci beaucoup. Juste une dernière petite chose par rapport à ça. Est-ce que le commissaire à la vie privée a été consulté ou est-ce qu'il est... est-ce que... J'espère que ça ne pose pas de problème, du moins avec le commissaire de la protection de la vie privée. Merci.
Okay, thank you again for the question. So the Privacy Commissioner directly was not consulted. That office will be consulted as part of the regulatory process. Obviously, with these types of programs, there's information that's going to have to be sought after by, again, local law enforcement, RCMP, and the department to determine that risk assessment. So as a result, you'll notice in the bill, page 5, talks about conflict with the Right to Information and Protection of Privacy Act. So keeping that in mind, that this bill would trump some of that information, some of that legislation in relation to privacy, because again, the information has to be obtained in order to produce some sort of risk assessment. However, within that bill, it also very clearly lays out those safeguards to ensure that that stays within its lane of the intended purpose of the bill, so that the information collected, again, is not disclosed to the applicant or anybody else, and as well to ensure that you know, the department and law enforcement is not handcuffed to find information out, because the issue we have is if we didn't have those sections in the bill in relation to privacy, law enforcement and the department would be unable to get that information to assess, to be able to give the assessment to the applicant that's giving it, again, in a verbal way without specifics. So there is sections of the bill that would trump the Information and Privacy Act, but it does have enough safeguards in it that I'm confident would keep that information directly related to the program in a very small, narrow scope of people that would be implementing that program.
Merci pour la réponse. Ça tombe bien parce que c'était ma prochaine question. Parce que le ministre a donné beaucoup de réponses, mais je veux quand même le soulever parce que le fait que ce projet de loi passe par-dessus la loi sur la protection de la vie privée, si je me rappelle bien, là, de prime abord, comme un législateur, ça m'apparaît un peu dangereux ou inquiétant, préoccupant, c'est les termes qui me viennent. Ouais. En d'autres mots, j'apprécierais, le ministre l'a fait, mais j'apprécierais qu'il le fasse de nouveau, avec l'angle que je viens de dire. Parce que quand on passe par-dessus une loi aussi importante que la protection de la vie privée, il y a des risques associés à ça, selon moi. C'est risqué, c'est un pari risqué. Donc, est-ce que le ministre pourrait un peu réitérer sa réponse à la lumière du fait qu'il y a des risques associés à ce qu'ils font et comment ils ont fait un peu pour mitiger ces risques-là? D'abord, peut-être le pourquoi de le faire et pourquoi il est confiant que ce qui est dans le projet de loi va mitiger pour s'assurer qu'il n'y ait pas de débordement. Parce que si le ministre l'explique bien, je peux vivre avec. Mais j'apprécierais une explication un peu plus claire de pourquoi c'est nécessaire de le faire et puis comment on fait pour mitiger les risques, parce que, regarde, c'est clair qu'il y a des risques en faisant ça. Merci.
Okay, thank you, member, for that question. And indeed, again, the challenge in introducing and developing this bill was, part of my preamble between ensuring privacy, but also having enough authority to be able to do a risk assessment. The problem is if this bill had to fall under the Privacy Act without any exceptions, it would neuter the bill. The bill would be of no use, because then there'd be no way to get the information to be able to get that assessment for the applicant that's asking for it. So it's a valid question for sure, but I guess what I would point to is sections of the bill that really zero in on how that information is used, because any time a piece of legislation trumps the Privacy Act legislation, then obviously there has to be safeguards within that to ensure that, you know, the intended use is only used for the intended use. The information is only used for the intended use. So if you look at the bill, you can look at Section 7, where it says directly, conflict with the Right to Information and Protection of Privacy Act, talks about it number 7. It also goes on to number 8 of the bill, and then if you get into disclosure of information, 10 and 11 also talks more about that, how you can information be disclosed, and that's why it gets back to what I said, that it's a verbal risk assessment, again, to ensure that that privacy element is not lost. Even though this bill trumps the Privacy Act, privacy is not lost because there's enough checks and balances built within the bill to ensure that is only used for its intended purpose. I hope that helps alleviate some of the concerns and answers the question. Again, a valid question because it gets back to my original introduction. It is the balance between privacy and being effective as a bill to enable the applicant to get the information they need to determine their relationship and the potential problems it may have. Thank you.
Merci, Monsieur le ministre, via le Président, pour cette réponse. Vous m'avez rassuré, Monsieur le ministre. Vous avez bien expliqué, selon moi, comment, par rapport à cet élément-là, je ne parle pas pour l'ensemble du projet de loi, mais par rapport à cet élément-là, au moins, vous m'avez bien expliqué le pourquoi et vous m'avez bien expliqué le pourquoi on doit le faire et qu'il y a quand même des garde-fous pour s'assurer qu'il n'y ait pas de débordement. J'apprécie que vous réalisiez l'importance de ça, puis je pense que vous l'avez démontré dans votre réponse. Ma prochaine question, et je trouve que c'est un élément important en fait de ce projet de loi, en fait quelque chose que je considère positif. Le ministre a parlé dans une de vos précédentes déclarations qu'il y aurait un service supplémentaire fourni dans le cadre de ce projet de loi, qui serait peut-être comme un à côté, où il pourrait avoir, à travers toute cette démarche-là, des services et des programmes qui pourraient traiter de la prévention de la violence. J'apprécierais si vous pourriez élaborer là-dessus. Je pense que ce serait bien, parce que je trouve l'idée très intéressante et je pense qu'on pourrait en bénéficier, nous tous, si vous seriez en mesure, Monsieur le ministre, de nous décrire un peu en quoi ça peut consister, de tels programmes. Merci. Et expliquez aussi la démarche, le pourquoi et le comment, si c'est possible.
Okay, thank you. Excuse me. Thank you, member, for the question. So, I guess to put meat on the bones of the bill, as I would say, you know, it's one thing for the bill to say, look, you know, an individual makes an application, they're found to be a legitimate application, they sit down with law enforcement after, you know, the process has been done. Law enforcement then turns around and says, you know, based on our assessment, you are at high risk. If the bill ended there, what's the individual to do, right? So what is part of this whole process is that it doesn't end there. At that point, then law enforcement can guide that applicant to where they can receive services based on that assessment. So whether it's, you know, domestic violence outreach organization, whether it's through Women's Equality, which has, you know, different options for women that find themselves in that situation. But the intent behind this is not just to simply to say to an applicant, you know, listen, based on what we've seen, you're at high risk, have a good day. This is to say you're at high risk, and here's the services that we offer. Now, obviously, you can't force anybody to take these services, but you can say, look, you're at high risk. We want to encourage you to reach out to, you know, these different branches, these different organizations that can help you navigate, you know, the problem you're facing in relation to your relationship. So, again, that's the part of this that I think is a holistic approach, where it's not just the risk assessment, but it's also a follow-up to allow the applicant the opportunity to seek out different services which would be offered as part of that assessment. I hope that explains it. Thank you.
Oui, Monsieur le Président, ça répond très bien à la question. Et je suis content que j'ai pu donner une opportunité au ministre de l'expliquer un peu, parce que je pense que c'est un élément important, parce que on peut potentiellement éviter. Le but de ce projet de loi, c'est d'éviter que ces choses-là se reproduisent, puis ce service-là pourrait effectivement avoir un impact positif. Ma prochaine question est reliée à la formation. Est-ce que les policiers ou les gens responsables de procéder avec cette nouvelle façon de faire, cette nouvelle activité, ce nouveau programme, est-ce qu'il va y avoir une formation sur deux éléments? La première, c'est sur comment recueillir l'information et qui va le faire, comment cette information-là, il doit y avoir une espèce de certaine formation. Puis l'autre formation, est-ce qu'il va y avoir une formation sur comment livrer cette information aux gens, aux demandeurs? Donc, si vous pouviez un peu m'éclairer là-dessus, ce serait apprécié. Merci.
Okay. Thank you again for the question. So the way this would work is, again, the application would be received, vetted, approved or not approved, but supposing it's approved. At that point, the police would do data collection, get the information together. They would then submit that information to the Department of Justice and Public Safety within that program, and they would go through that information to formulate an assessment. Once that information has been gone through, sifted through, and an assessment is given, then the assessment is then given back to law enforcement, and law enforcement would then sit down with the applicant to go through what that assessment is. Again, there's no paper documents. This is all verbal, balancing that privacy issue. But it's a coordination between the department and law enforcement so that we have adequate, accurate information to give. What we don't want is, obviously a wrong assessment. We want to make sure the assessment is accurate based on the information that is collected by law enforcement and that is sifted through by the department. So there's very much a coordinated effort between our department and law enforcement to ensure that those assessments are accurate. And that's basically how that process would work. And I don't know, member, if you had another question that I maybe missed in there. Training, thank you. So training is absolutely something that is always ongoing. The Women's Equality Branch, I understand, has a role to play in that and has had a role to play in that for police and law enforcement, police agencies, to be able to understand better domestic violence issues and some of those things that go on. So in relation to training, training is always ongoing. It will continue to be ongoing, specific to this bill. And again, that training aspect, I think, would also be covered under the regulatory process.
Thank you, through the chair to the minister. My question was essentially about the training, which the minister did answer. It's funny because it wasn't part of my questions, but one of the answers, the previous answer by the minister, made me ask a question and made me realize something. I was thinking all this time that it would have been law enforcement that were conducting all of these inquiries, but what I just understood, and if I understood correctly, that it's employees of the department that will conduct this. So can I have a confirmation from the minister that it will be indeed department employees that are going to conduct those investigations, and then they're going to give the information to law enforcement, and then law enforcement is going to meet? Okay, I see them nodding their heads, so I just got my answer. Thank you. So let me move on. I guess my question is what will be the difference of information between what the government employees tell law enforcement and what law enforcement tells the person asking? So my question is as follows. Is the government employees responsible for this program going to tell law enforcement, this is the answer, this is what you're going to tell the person, or this is the full report, but please just say this? I don't know if my question is clear, but that is my question. All right, thank you.
Okay, thank you again for that question. So what we want in the implementation of this bill and to ensure that applicants have an understanding of their risk assessment in the relationship, we want consistency. So the concern is if we simply allow police agencies to determine the assessment on their own, we may lose that consistency. And I don't mean that in any way to downplay the excellent work that police forces all across this province do, but you may have some consistency. RCMP may do it one way, St. John Police may do it another, Fredericton City Police, so you can see how there may be some issues there. So the idea behind this is those departments would gather and collect the information. It would be delivered to the department, then the department would have a consistent approach on every application to be able to take the information that they receive from the police forces, develop that assessment, and then give the assessment back to the police forces to be able to deliver to the applicant. So I hope that answers the question, but really at the end of the day, it's to ensure that there is a level of consistency with the process, especially considering that we have multiple police forces in New Brunswick.
Merci, Monsieur le Président, au ministre pour cette réponse. Ça a clarifié la question précédente, donc je l'apprécie. Et puis, je suis d'accord. Je pense que dans ce cas-ci, c'est une approche qui m'apparaît tout à fait logique. La prochaine question, c'est au niveau de... Est-ce que dans l'enquête, on touche simplement des choses qui touchent la violence domestique, ou est-ce qu'on touche d'autres crimes potentiels, des crimes qui sont pas reliés ou peut-être un petit peu reliés à de la violence conjugale, par exemple le fait d'avoir fait un vol armé. Est-ce que ça serait indiqué? Est-ce que ça fait partie des éléments qui seront considérés dans l'évaluation? Est-ce que d'autres crimes à caractère violent, mais qui ne sont pas de la violence conjugale, vont faire partie de cette évaluation? Vous comprenez, là, est-ce qu'on touche uniquement la question de la violence conjugale, ou est-ce qu'on va regarder quelque chose d'un peu plus large? C'est la question. Merci.
Thank you, Minister. Good question, and I guess I'll just give a very straightforward answer. The bill is designed so that only information relevant to domestic violence. So if someone had a fraud charge or conviction, that's not going to show up in this assessment. So you are correct. It would only be related to incidents of domestic violence as part of the assessment.
Merci pour la réponse directe et claire. Je vais demander une nuance ou quelque chose de plus précis. Par exemple, si on parle de, c'est pas de la violence domestique, mais s'il y a eu un crime avec violence, évidemment un meurtre, même si ce n'est pas un meurtre conjugal, mais j'imagine que des crimes à caractère violent, qui ne sont pas de la... Est-ce qu'il y aurait pas matière à ce moment-là de peut-être le divulguer? Je pose la question parce que dans ma tête, il y a une logique à faire que si la personne ou le partenaire a des antécédents violents, même si ce n'est pas de la violence conjugale, est-ce que ce serait pertinent de le révéler? Merci.
Okay, thank you for diving down on that in terms of, you know, what information is used. So the answer is no. It has to be directly related to domestic violence. And I think one of the reasons is I'd just give you a practical example. If someone were to get in a bar fight, you know, we certainly wouldn't want, you know, an assessment to be raised because someone, when they were 19, made a bad decision, drank too much, and you know how it goes. So no, this has to be directly around domestic violence. And again, based on what we've seen in the statistics and the data, a lot of these are repeat offenders. It's a lifestyle for a lot of these, well, I got names for them I won't use here, but people that commit these acts. So the bill is really focused around domestic violence, and it needs to be centered around that.
Thank you very much, Minister. I think at this time we'll take a health break. Meet back here at 3:30.
Call the committee back to order. I recognize the member from Kent South.
Madame la Présidente, merci bien. Si vous entendez des cris derrière moi, c'est parce qu'il y a le match de la Coupe du Monde Canada-Belgique, et puis c'est 0-0, mais bon, ça brosse. Bon, je reviens au projet de loi. Le ministre avait bien expliqué un peu comment tout ça fonctionne. La prochaine question que j'ai, le ministre a déterminé que ce serait des employés du ministère qui vont être habilités à approuver les demandes et à faire les enquêtes. C'est ça, j'ai compris. Donc, si je comprends bien, ce sont des gens du ministère qui vont faire la procédure de déterminer le vetting, comme on dit en anglais, là, qui vont déterminer. Donc, ce sont des employés de ministère qui vont faire ça. C'est bien ça? Oui, OK. Je vois les têtes qui font signe que oui. Merci. Je voulais juste... Attends, je suis juste en train de regarder les différentes questions que j'ai ici. Si jamais, est-ce qu'il y a une disposition? Puis j'ai bien compris que le ministère a fait son possible pour éviter des débordements. Tu sais, au niveau de la protection de la vie privée, de ne pas en donner trop. Mais si jamais qu'il y avait une erreur qui se produit, vous savez comme moi, un système est juste aussi bon que les humains qui sont dans le système. Des erreurs vont être faites. La question n'est pas si, la question est quand. J'espère. Puis on est tous d'accord qu'on veut éviter ça, puis on souhaite que ça n'arrive pas. Mais quand ça va arriver, j'espère dans bien longtemps de maintenant, est-ce qu'il y a une procédure pour contrer ça? Est-ce qu'il y a des mécanismes que si jamais la personne qui est enquêtée venait apprendre quelque chose, ou qu'il y a quelque chose qui a été une mauvaise information qui a été transmise, ou une mauvaise évaluation, et que ça a des conséquences négatives, est-ce que la province peut se faire poursuivre? Et essentiellement ma question, est-ce qu'il y a des mécanismes qui sont inclus dans le projet de loi pour traiter de la question? Merci.
Thank you, Member, for that question. So, yeah, I mean, with any legislation, with any program, with any government service delivery, you know, the civil servants, the people working these programs and policies, you know, they do their best at all times to to, try to deliver those services in a way that is in good faith and that is, done in a way that produces the results of what the legislation was intended for. Obviously, there are occasions where, things don't go the way that they should. What we don't want is, these people that are delivering these programs and these services that are doing so in good faith, to have any, sort of backlash, because through the process something went south, again, keeping in mind the good faith part of it, that they're doing it without malintent or whatnot. So there's checks and balances like there is in any other department, any other program, any other service. If something is done erroneously, they'll double back, have a second look at it, see what went wrong, what can be fixed, and it would be no different with this bill. Now, I'm optimistic that the assessments that are done will have enough rigor that they will be accurate in their delivery. Again, you've got a lot of people involved in this, in terms of law enforcement and within the department, that's going to be scouring through this information and the data. And again, the benefit of having the department involved in that data collection and to actually formulate the assessment is that you do have a standard of consistency that will be there, whether the applicant goes to the Miramichi City Police, St. John's City Police, or RCMP or any other law enforcement agency. The department internally is able to get that information, have that standardized, consistent level of assessment, and then bring that assessment forward. So I'm optimistic that the assessments will be accurate. But again, in the rare occasion that it's not, those are issues we will have to deal with as a department and learn from them and make sure that it doesn't happen in the future and try to make the program better.
Merci, Madame la Présidente, à travers vous, au ministre, pour cette réponse. Puis c'est la réponse à laquelle je m'attendais. Oui, OK. En d'autres mots, je comprends et puis on espère que ça n'arrivera pas et on va souhaiter que le système va toujours s'améliorer pour l'éviter toujours encore plus. Ma prochaine question, maintenant qu'on sait, là je m'en vais aller dans un peu plus, j'achève, là, il me reste que quelques questions. J'aimerais savoir combien, à cette heure, est-ce que ça vient avec des ressources? Est-ce que ce projet de loi-là vient avec des ressources budgétaires? Parce que là, on se trouve avec des gens du ministère qui vont effectuer de nouvelles tâches. J'aimerais savoir combien de personnes sont prévues pour faire ces tâches-là, combien de postes, est-ce qu'on parle de la création de nouveaux postes, est-ce qu'il y a une enveloppe budgétaire, c'est quoi cette enveloppe budgétaire? Je pose plein de questions pour éviter que je me lève tout ça. Et puis, si le ministre est capable de donner toutes ces réponses-là, ça serait apprécié. Merci.
Thank you, member, for that question. I've always been known as kind of a fiscal guy myself to ensure things are done right. So one thing I do want to say, I guess, to start out is another benefit that I don't think I mentioned earlier about having the assessment done internally is what we didn't want to do was put more strain on police resources. I know everybody's well aware that police resources in this province are struggling, and as a minister, as a department, we are working to try to get through those challenges to ensure policing is done better in New Brunswick with more resources. So what we don't want to do is create another program that's going to tie up those police resources. So hence the reason why, if it's done internally, the staff at JPS can do a good portion of the legwork in these instances, in cooperation with the police, but that we're not tying up the police to implement this program. In terms of the actual numbers, it's a good question, but it's one I can't answer right now because I simply don't know. Volume is going to play a big part of that. I don't suspect we're looking at any huge numbers in terms of the cost associated with this bill and the program that comes out of the bill. Saskatchewan, for example, had a low amount of applicants that came in the run of a year. Alberta had a high amount. So it really depends on how many applicants we receive into the department. And I'm confident we have the staff currently, to be able to implement this once the bill passes royal assent. The program, the regulations, everything is in full force. But I can tell you that if we get to a place where, look, we've got a lot of women out there that want this information, and we get a lot of applications that come in, I can commit to you as a minister, I'll be knocking on my good friend, the Minister of Finance door to say, we need some extra funding or resources to make this work, and I know the Minister of Finance would be more than happy to help in this situation. But right now, I don't see that being an issue. I think the resources will be there to be able to effectively implement this program should it pass this House and receive royal assent. Thank you.
Thank you, through the chair, to the minister for that answer. I guess, and I appreciate that answer. I understandably. I mean, we certainly don't want to see our deficit increase with too much. Oh, wait. No, but joking aside, what is important in my mind when it comes to this is the promotion that we do about it. If nobody knows about it, then nobody's going to do it. People are not going to use the service. So a service is only as good as it's used, and it's good as it's promoted, especially when you start. So vaccination is an example of that. It's just, but when it comes to this obviously is a good program. It's a good bill. It's we want to make sure that this bill has an impact, but in order to do so, people need to know about the service. So my next question is, what is this department's plan on promoting this new service to make sure that people know about it and people can use the service? Thank you.
Thank you, Madam Chair. A valid point. I couldn't agree more. You know, I always say, you know, you can have the best programs in the world as a government, but if nobody knows about them, what's the point? So we will internally as a department be promoting this very heavily, you know, through multiple media formats, Facebook, Twitter, social media, different platforms there. Obviously working through domestic violence organizations, women's shelters, police agencies. You know, I even think of, again, our guest that's here today, Colette, who you know, advocated for this type of thing. You know, it's going to take everybody working together to ensure that people know about this. All of us as MLAs will have a role in that, to get the word out. You know, we have Domestic Violence Awareness Week. We have avenues that we can push this information out through all of our partners, through, you know, through our government, through our department, of course. But we all play a part in information, and we will do that. We will do everything we certainly can as a department to make sure people are aware of this program so they can utilize it, again, as a tool to mitigate domestic violence.
Merci beaucoup, Madame la Présidente. Bon, ben moi, ça conclut un peu où je voulais aller. Je sais que j'ai d'autres collègues qui veulent poser d'autres questions. La seule chose que je terminerai en disant, c'est ben merci au ministre pour les réponses, les bonnes réponses, les réponses franches. Mon impression est que c'est de la bonne législation et que, tu sais, évidemment, tout ce qu'on peut faire pour réduire la violence domestique, ce n'est qu'une bonne chose. Par rapport à la promotion, je pense qu'on sent la bonne volonté du ministre. Je pense que ça va être important, puis là, je me permets de faire une observation, qu'il y ait un plan un peu plus clair, un peu plus détaillé. Je comprends qu'on est encore dans la question de la réglementation, mais je me permets de faire la suggestion au ministre et au ministère d'avoir un plan de promotion clair et détaillé. Parce que juste des vœux pieux, souvent, on dit oh, oui, on va le faire, mais comment vous allez le faire? Ben, on va y porter. Plus ça peut être concret, plus efficace que ça va l'être. Et puis, je vous suggérerais également d'aller voir les organisations, celles que j'ai parlé au début, là, celles qui sont capables, qui sont sur le terrain, qui comprennent la réalité du terrain en matière des personnes vulnérables, la population vulnérable. C'est essentiellement, chez nous, ben, c'est le Centre de prévention de la violence de Kent, c'est le Centre de crise familiale Beau Séjour à Chédiac. C'est ces gens-là qui, en tout cas, moi je commencerai là. Donc voilà, c'est là où j'en suis. Le ministre est bienvenu de réagir, mais moi, c'est l'essentiel de mes questions. Puis je remercie le ministre et je remercie aussi beaucoup son équipe, que je sais qu'il travaille très, très fort pour l'épauler. Merci beaucoup. Merci, Madame la Présidente.
Thank you, member, for that. And I think you're absolutely right. You know, it's nice. It's not very often that we see a bill presented where, you know, members of the opposition are asking us to promote it. So this is good, and I mean that in a positive way. That shows that this bill is important among all political parties of all stripes. So this is good, and I couldn't agree more. I think that it gets back to what I said a moment ago. If it can be the best program in the world, but if people don't know about it, it's somewhat useless. So we have to promote this. We have to promote this hard, using all our partners, individuals that have been through, you know, these traumatic events, you know, to get the word out. And thank you, member, for that, and I certainly take that under strong consideration. Thank you.
Okay, I recognize the member from Bathurst West, Beresford.
Figure I'm playing whack-a-mole. Thank you, Madam Chair. I just got a couple of questions around, especially on the impact of this bill and around the support that's going to be needed. I know we just talked about overwhelming police officers with the requests and if there's going to be resources available. I'm more on further down the line, and I'm ill-equipped, I know, I've got very little experience with domestic violence, and ill-equipped to see where the process really gets hard and where somebody's in a relationship where it becomes dangerous and when it becomes hard for them to be out or to get some help. But I do know it's a hidden situation, and even if we promote it and there's more cases of people asking for help, doesn't mean there's more violence. I think the violence already exists. It just comes out to light. I've got an experience. As many of you know, we own a small operation, a small brewery, a small tap room. There's only so many chairs, 40, 50 chairs. We know our customers. We know who comes in every day. And last year, an organization back home put you know those sheets where they put your organization and they cut the phone numbers on the bottom so you can just pick up a phone number. And it was for domestic violence, and it was called the number if you need help. And we said, you know, yeah, sure, but we know everybody, right? They've changed the sheets twice. All the numbers were taken. It's amazing. It floored me. So I'm kind of wondering if you've been in talks with social development, who might get a lot more requests for help, for protection, because I imagine all these organizations are heavily funded by social development. Has there been any preparation or any resources allocated for potentially, if this works, you don't want to talk about this like it's a goal for it to work, but if it helps more people, if it helps more women or more people that are in trouble, so be it. But will the back-end support on social development, has your department talked on that aspect to see that the help will be there?
Yeah, I thank you for that question. I didn't realize you had a tap room. You should invite me for a beer someday. But yeah, no, look, absolutely. In a program like this that is good, every department should be utilized in promoting that, and social development certainly would be one that would, you know, utilize its clients or utilize the information to get to their clients to ensure them that the program's there and that it exists. You know, getting back to the previous member and kind of what he said, my biggest, I wouldn't even call it a concern, but a little worry is not so much the context or content of the bill. It is indeed that the word gets out enough that people know it's there. And look, what you do in your tap room, I think, is great. We need other places like that to do that same sort of promotion to help us carry that message forward. Social development, I think, will play a part, whether it's something through Department of Health or any other government department that works with folks that are at risk of domestic violence. We would certainly utilize nonprofit groups. There has to be an interconnected. But the interesting thing today is, you know, 50 years ago, if you had a program like this, you put it in the newspaper. And that's about as far as you could go, maybe a radio, TV ad, that'd be about the extent of it. But today, there's so much information out there, and information is so much readily available. I think the trick today is not necessarily getting the information out, it's standing above other information so people can highlight this particular program. So we're going to have to get creative with that as a department to ensure that that promotion is there. But again, I think it's going to be all hands on deck. I think JPS has a big role to play in promotion, but I think it's going to take all stakeholders, again, to promote this, to get the word out. This tool is available. you know, to an individual, if you have questions about your relationship and the person you're with, and you know, maybe you're new in the relationship and you just need a little more security in your mind and your heart about this individual, this is now a tool available to you to check that out. So there's got to be creative ways to promote it, but I agree wholeheartedly, every government department, all of us, should be helping to do that.
Thank you, Minister. Through the chair, I just want to reframe the question, because I wasn't asking about support from other departments to promote it. What I'm worried about is if somebody hears about it, utilizes it, and the help that is needed from social development or through these third-party agencies or partners, are they funded, are they prepared, have they got the resources required to get that influx, potential influx of new people asking for help? Have you gotten confirmation, or are you confident in speaking to your colleagues in other departments, specifically social development, that that help is available, that there is capacity there to handle that?
Yeah, and I apologize. And again, valid point. So right now, without this bill in place, we're dealing with after-the-fact statistics. So the incident has already occurred. Police have been called, reports have been made, so now we have very general statistics on domestic violence in New Brunswick. It's good in the sense it gives us an idea of what's going on in our province, but it doesn't do anything in terms of preventative measures. So with this program, it's not going to take us long to get a better understanding of how many individuals are reaching out for help. You know, we'll know, and as I said earlier, Saskatchewan in the first year had a handful of applications. Alberta in the first year had over 100 applications. So it varies. In New Brunswick, we will see, based on promotion, based on how many people utilize the program, we'll get a very clear understanding, I think, early on to say, look, we may already know domestic violence is a big issue, but again, it's an after the fact. But now we literally have people that are saying, I want to take a step, I want to be preventive, so this doesn't happen to me, and I think that's going to up the ante. I think that's going to cause us as a government, nonprofit organizations, other individuals to really rise up to that and say, you know, it's important to help people that have gone through this, but how can we help people that haven't gone through it and are doing their best to avoid it? You know, so that it doesn't happen in the first place. So good point, and I think the program, when we see the applications coming through this program, we're going to quickly realize how many people are out there that need it. And if we're falling short somewhere in terms of those wraparound supports, well, we need to look at that and ensure that those supports are there. I think that's important.
Thank you. Thank you for the answer through the chair. Interesting point. I wonder if you've dug into it, and this is my lack of knowledge, but in the two provinces where they see numbers of increase or calls, and in my mind, I feel like if somebody is an abuser, they start off as an abuser in a relationship, and I wonder in those cases, was there any examples of when individuals were searching out to be preventative, that it would, I don't know what you would say, ignite the abuse, where, you know, I don't think it starts off abusive, but you build into it. Has there been any case where somebody, you know, just looking for information created a situation where the abuse started and it became an accelerated or an augmented risk situation out of those cases?
Yeah, so the similar question was raised by your colleague earlier in relation to when the application is made in terms of confidentiality. So the good part of this program is that if an individual submits an application, that's confidential. So while JPS and law enforcement are doing their work behind the scenes to collect the data and provide a risk assessment, the individual they're collecting the data on has no clue that this information is being gathered, for obvious reasons. For just as you stated, what we don't want is you know, the individual that's being looked at coming back on the applicant. So this bill ensures that confidentiality, so the applicant, when they come to fill the application out, they can know with assurance and confidence that their name is not going to be disclosed to their partner. So that takes that equation out. Now, if the applicant chooses to tell them, which I don't know why they would, but if they do, then, you know, there's not much we can really do about that. But in terms of our part, completely anonymous and confidential in regards to the applicant.
Thank you, Minister, through the chair. You know, this is the conversation we need to have so I can understand it. I guess my point was that I guess the tipping point is if somebody makes a call, I was very confident that it would be anonymous and that there was no way for the person being verified on would get the information. But I just imagined that the partner showing up and saying, okay, this relationship is done without giving a reason, all of a sudden dealing with an abuser, that would be a heightened situation. So is there a buffer zone or protection of saying, okay, you are dealing with an abuser, you are in a relationship with an abuser, you haven't been abused yet, do they automatically go into some form of protection mode, or is there a transition out? I hate to kind of like put steps in this stuff because it's very, very difficult. It's difficult situations, but I'm just trying to see how it lines up so that that person is completely protected through and nothing slips through the cracks.
Okay, I think, member, you raise a good point. So the assessment's been made, and we're just going to break this down here. The assessment's been made. The applicant now knows they are at high risk with this person they're with. So, as I said earlier, the idea behind this is not just to simply say, ma'am, you're at high risk with this individual, good luck. The idea of this program is to say, ma'am, you're at high risk of this program. Here's options you have. So whether it's you know, an organization through Women's Equality, one of the organizations through there, whether it's a transition house, we're working on a wraparound service to give people options when they find themselves in that predicament. I mean, obviously, it's up to the individual to decide whether they want to utilize those options. We can't force them to. But we do need to have some mechanism there that people that fall in that high-risk category don't feel like they have to stay in that high-risk category. And that's going to take some work. There are some support services that are there now that I think people can utilize, but we do need to build on that. I'm not going to shy away from that. That's something that government as a whole, social development, Women's Equality Branch, JPS, all of us have to find ways to expand that and make it realistic so that people have options. And that they have a reasonable chance of utilizing those options. So valid point, and something, again, we have to build on.
Thank you, Minister, through the chair. That was what I wanted to clarify. I'm very happy with that answer. It's going to be important for first responders and people that are involved in the program to have a very clear definition, because these are quite often very quick response times, and there's only moments to act, so you need to be very clear on how. So having options and having a clear direction where to go is awesome. I do want to take the time to thank the Minister for his answers, thank the staff for being here. I do want to acknowledge your guest. Madam, you are not only a survivor, you are a true living hero. It's an honor. Thank you.
Le député de Québec.
Merci beaucoup, Madame la Présidente. Donc, merci à l'équipe, merci au ministre d'être ici pour parler de ce projet de loi ici. Un projet de loi important, que je veux dire d'emblée, qu'on va supporter. C'est un outil de plus, mais il faut quand même arriver à mieux comprendre l'outil, puis de comprendre comment ça va fonctionner, puis comment est-ce que ça va se transmettre d'un projet de loi à quelque chose de concret sur le terrain. Et donc, j'aurais quelques questions. Puis ma première question, c'est un peu pour faire suite à la question du député, mon collègue qui parlait juste avant moi. Puis ça vient aussi en lien avec une réponse que vous avez donnée tout à l'heure. Puis je suis un peu déconcerté, par contre, du manque de consultation avec les services disponibles, les gens qui travaillent avec les victimes de violences familiales ou de violences entre partenaires intimes. Et donc, vous dites dans la dernière réponse que les gens qui font appel auront la possibilité ou seront envoyés ou dirigés vers des services nécessaires ou disponibles. C'est clair qu'on ne peut pas forcer personne de prendre ces services-là, mais il y en a certains qui décideront de faire appel à ces services-là. On le sait aussi, en consultant avec les gens qui travaillent dans le domaine, que les ressources sont déjà très minimes. Ils sont déjà sous-financés. Et donc, ma question pour vous, Monsieur le ministre, c'est, en implantant ce projet de loi, on peut prévoir dorénavant, déjà, une augmentation du besoin de ces services-là. Et donc, quelle sorte de ressources, que ce soit de l'argent, que ce soit des ressources humaines de plus, dans les centres de prévention de la violence ou les maisons de transition, quelle sorte de ressources allez-vous, qui vont accompagner ce projet de loi ici pour les groupes qui travaillent avec les intervenantes qui travaillent avec les victimes de violences de partenaires intimes?
Thank you, member, for that question. So, you know, currently there are resources available for individuals that find themselves a victim of domestic violence that can be utilized. This program would connect with that as well in the same regard. So, again, one, unfortunately, is after the fact. The beauty of this is it's preventative, so it's to stop it before it starts. And those wraparound services that I spoke about earlier to the member that had asked about it is just that. And we are going to, I believe we're going to quickly get a pretty good gauge of where we are as a society in terms of what supports we have. As I said earlier, you know, Saskatchewan and Alberta, you see a big gap. You see Saskatchewan had few applications, Alberta had a lot. You know, if we are promoting this the way we should, And New Brunswickers are grabbing a hold of this, and the information's out so people know it's available. And if we start to see the applications flow in, and indeed we're getting a high amount of applications, that's going to trigger for us that, look, we need to ensure these support services are available, and if they need more funding or more tools, then we will do that. We will commit to that. But I think that will be determined early on. I think what we've got now are services that are there. I mean, the argument can always be made that, you know, maybe they're not have enough resources, and that's a legitimate debate. But they are there now, and they'll continue to be part of this program. How they expand and where they go, and what other tools we can use to complement this bill, absolutely. I think it needs to be wide open so that people have the supports they need. It's very simple. Why wait until after an incident occurs to help someone when we can help them before? This is the first step to that.
Merci beaucoup. Je comprends qu'on veut ajouter un outil pour avant que ça arrive, mais on le sait aussi, les études nous démontrent, les intervenantes nous le disent, que souvent, ignorer un problème comme ça fait partie du mécanisme d'adaptation, coping mechanism en anglais. Donc, il serait réaliste, je crois très réaliste, de savoir que ce n'est pas tout le monde qui vont accéder à ce service-là avant les faits. Et donc, je pense que probablement, on verra, comme le ministre dit, mais certainement, il y a plusieurs personnes, lorsqu'ils font l'appel, vont avoir besoin déjà des services. Donc, de la réponse du ministre, j'ai compris qu'il n'y a aucune ressource qui vient avec ce projet de loi ici. Je veux juste m'assurer de bien comprendre. Est-ce qu'il va avoir, parce qu'on parle de prévention, hein? Vous l'avez dit vous-même, Monsieur le ministre, et donc, si on parle de prévention, bien, on peut déjà prévenir que les intervenantes, les ressources sur le terrain vont avoir besoin des ressources pour dealer avec ceci. Et donc, est-ce qu'en prévention, en sachant qu'il va y avoir une augmentation des appels, est-ce qu'il y a des ressources rattachées à ce projet de loi ici?
Okay, thank you, member, for that question. And I guess, to be blunt, there's probably a few things we agree on, but prevention in terms of domestic violence, I'm sure, is one we would agree on. So, in relation to this bill is really geared towards prevention. If someone is in an unfortunate relationship where they've already been the victim of domestic abuse, this bill, I mean, it's open to them, but it's really going to probably just confirm what they already know and are already experiencing, unfortunately. So, you know, they have avenues that they can use, supports that they can use that are there for them if they choose to use them. This bill really is again, it's to get ahead of it. It's you know, someone's in a relationship, they've met someone, they're starting to build that intimate relationship. but there's something in the back of their mind that just has that red flag. Or maybe there's no red flag. Maybe they just want that extra confidence. Well, that's what this is for. This is the opportunity for that person, whether it's a red flag, needing that extra security, whatever it is. They don't even have to tell their partner that they're doing this. As a matter of fact, I recommend they don't. This is completely confidential. They have an anonymous application process. They can get that information, and then if it comes back, look, you're at low risk or whatever the assessment comes at, it helps them. If, on the other hand, it comes back and the person realizes, I don't know this person as good as I thought I did, that's going to show. We're going to be able to see that. The applicant's going to be able to see that. So at that point, you're right. We have to know that those services are there should the individual want to utilize those services. But we can't know that until this receives royal assent, until the program's in place, and we start to see what we're getting back from applicants. We do have data right now that shows where we're at with domestic violence, but again, that's an after the fact. This here is based on before it happens, what kind of responses are we getting, how many applicants are we getting, and that's going to, again, give us a good gauge to what we have. And then we can look at the resources as well and say, look, we got A, B, C, and D for these folks, but B needs a little more resources, or maybe we need a D option, maybe we need something else. So this is a starting point to the preventative side of domestic violence, and that's really what this is spearheading.
Merci beaucoup au ministre à travers la présidente. Absolument. Puis pour que ce programme ici fonctionne, parce qu'on sait déjà que la grande majorité des cas de violence entre partenaires intimes ne sont pas reportés à la police. Donc, pour que ce programme ici fonctionne, il va falloir que des personnes rapportent les agissements de violence entre partenaires intimes. Et donc, on peut déjà prévoir, si vraiment, sincèrement, on veut que ce programme ici fonctionne, on peut déjà prévoir qu'il va y avoir une hausse des demandes, des ressources qui sont présentement disponibles. Du moins, il faudrait qu'il y aurait une hausse de demande si on veut que le programme fonctionne, parce qu'on veut que les gens rapportent ces agissements terribles-là. Donc, ma suggestion au ministre, ma humble suggestion, c'est que pour que ça fonctionne, il faut qu'il y ait des ressources de mise en place, parce que sans ça, les mêmes problèmes à la base vont demeurer, que les gens ne rapportent pas les incidents, et donc l'outil ne sera pas complet, parce qu'il y a plusieurs noms qui ne seront pas inscrits dans l'outil. Donc, ça c'était mon commentaire. Là, j'ai quand même une autre question au niveau... Je sais que vous avez parlé à des questions de collègues qu'il va y avoir des campagnes de sensibilisation pour assurer que les Néo-Brunswickois et Néo-Brunswickoises savent que ce programme-là existe. Et vous l'avez dit vous-même, probablement ce qui va faire en sorte que les gens appellent, c'est qu'ils ont ce sentiment-là, ici derrière la tête. Mais pour ça, il faut qu'ils soient capables de reconnaître certains signes précurseurs. Comme que je disais, les études démontrent que souvent, on va mettre de côté ces signes précurseurs-là comme mécanisme d'adaptation à la situation. Et donc, est-ce qu'il va y avoir une campagne de sensibilisation rattachée à la mise en place de ce projet de loi ici sur les signes précurseurs de violence entre partenaires intimes?
Okay, thank you for the question. So, I mean, currently there is some awareness campaigns that are going on in relation to domestic violence. There's Love Shouldn't Hurt, which is something the government has promoted, tried to get out there to as many people as possible so that they can understand some of the red flags that may be there in relation to domestic violence, so that they can kind of watch for the warning signs. This bill, and again, the bill, and then once the program's implemented, would tie into all of that. So you're right. I mean, someone who maybe wouldn't understand the warning signs, maybe they're not. I want to be careful here, but they're not in tune with what they're seeing, and because a lot of these cases, it's often the outside people of the relationship that will look at the relationship and say, something's off here. The people in the relationship or the individual in the relationship maybe isn't seeing it. So these programs are designed to help people better understand the relationship they're in and to be more aware of some of the warning signs that might be in place. So this program, once the bill is passed, would tie into that. And it does. It has to be a holistic approach that here's the information of warning signs you should watch for. If you see these warning signs, here's a program that is now in place that you can take preventative measures to at least get an understanding of the type of person you're dealing with in your relationship. So yes, I agree, it has to tie in together. And then of course we have the Women's Equality Branch, which fans out to different organizations. We have the police organizations, police agencies, which would also utilize this information, but it has to be a packaged approach that can go out, funnel out through all of these different avenues to make sure the information is getting out there that this program is utilized.
Merci beaucoup. Encore sur le terme des ressources, rattaché à ça, un autre élément que la recherche nous démontre de façon assez significative, c'est que la majorité des victimes de violences entre partenaires intimes ont des interactions négatives avec les forces policières. Donc, quelle sorte de formation qui va suivre ce projet de loi ici avec les forces policières pour améliorer le processus et disons, encore une fois, assurer, si tu veux, la réussite du programme. Parce que si les gens ont des mauvaises interactions, des interactions négatives avec les forces policières, ben, encore, ça a un effet boule de neige qu'il y a moins de cas qui se fait rapporter et donc il y a moins de noms dans le système et donc il y a moins d'informations disponibles. Donc, j'aimerais vous entendre là-dessus. Est-ce qu'il va y avoir de la formation offerte aux forces policières qui devront faire affaire avec ce programme ici?
Okay, thank you again for the question. I guess the simple answer is yes. There's going to need to be a certain element of training for law enforcement, to deliver these assessments. And I do want to get back again to what I said earlier in relation to how the program works. So the application first would come to the department. The department would then utilize law enforcement for data collection. The data collected would then, the department would then go through that data, determine the assessment, give it back to law enforcement to then deliver that assessment verbally to the applicant. So the training part in relation to that, yes, would be, the officer, whoever it is that is delivering that information, to be able to know in their mind through the training what programs are available, how to deliver the information. It can be, I can imagine, would be shocking for some if it is a high-level assessment that the applicant gets. So yeah, there's got to be a certain element of training there for sure that officers will receive to be able to deliver that.
Merci beaucoup. J'ai eu un élément de réponse de ma prochaine question, donc l'information va être donnée verbalement. Je vais peut-être demander ma question au lieu de concentrer sur le résultat, mais plutôt sur le processus d'application. Un autre que les études nous démontrent, un autre fait que les études nous démontrent, c'est que dans les cas de partenaires, de violence entre partenaires intimes, le monitorage des téléphones, des messengers, courriels, est quelque chose d'assez prévalent. Donc, sur le processus d'application et sur la réponse verbale, comment est-ce que, à travers du projet de loi, que vous assurez en fait, zéro trace? C'est ce que vous visez, zéro trace? Ou un minimum de traces? Je veux juste essayer de comprendre ce que vous entrevoyez à ce niveau-là.
Okay, thank you for that question. So that's kind of a two-pronged, I guess I'll answer it in two different ways. The one side of it is the application process would be online. So the individual, the applicant who's filling this out online, puts the information in, the information would come to the department, that's all encrypted, secure, private, all the checks are there. From the user side of it that's inputting the information, that may be a little trickier, of course, because they're obviously using a laptop, a cell phone, a computer, a PC, whatever they're using, to fill out the application. So what the department would do, and what others have done, is give some steps to that user on how they can clear their browser. There may be a button in there that they could, just hit to delete their cache or whatnot. So there's different ideas that could be utilized to protect on both ends. But I can tell you from the department side of things, once that application is submitted to us, it's treated like any other private confidential document, and it would be held securely.
Merci beaucoup. Ça, j'ai aucun doute. Je veux dire que le gouvernement traite les données des citoyens de façon privée. J'ai aucun doute. C'est surtout sur le côté de l'applicante que je faisais le commentaire. Ça sera très important de mettre un grand emphase là-dessus. Comme que je disais, les recherches démontrent que le monitorage de l'historique des pages web visitées, tout ça, c'est une réalité qui va souvent main dans la main avec la violence entre partenaires intimes. Donc, cela étant dit, pour l'instant, c'est toutes mes questions. Peut-être que je reviendrai après certains collègues. Je veux juste dire que c'est un outil de plus dans une boîte à outils. C'est pas l'outil final, c'est pas l'outil miracle non plus. Et donc, il faudra être très, très reconnaissant de ça, que c'est pas que ça devrait jamais être utilisé pour dire oui, mais on a fait quelque chose. Oui, ce quelque chose ici est un outil important. Donc, je félicite le ministre et son ministère de le mettre en place. Mais je fais juste un souhait honnête, sincère, que ça ne sera jamais utilisé comme oui, mais on a fait quelque chose. Tu vois. C'est un processus qu'on doit continuer à bâtir. Comme j'ai dit, je pense que mes questions entouraient surtout 3 thèmes. Donc, les ressources pour les intervenantes, que je remercie incroyablement pour leur travail. Avec les ressources qu'ils ont, ils sont déjà étirés au maximum. Donc, j'espère qu'il y a des ressources qui suivront. L'élément de sensibilisation sera extrêmement, extrêmement important. Puis l'élément de formation, surtout des forces policières, ne sera pas à prendre à la légère. Je pense que ça va prendre plus qu'une petite formation, ça va prendre vraiment... Parce que, veut ou veut pas, à la fin de la journée, c'est une déconstruction sociale de nos forces policières qu'il faut qu'elles arrivent pour qu'ils arrivent à traiter des cas comme ça d'une complète différente façon qu'ils le font en ce moment. Donc, il y a un élément de déconstruction sociale. Ça n'arrive pas facilement. En fait, c'est une des raisons pourquoi il y a de la violence entre partenaires intimes. C'est à cause de... On n'a pas passé à travers ces étapes de déconstruction sociale. La masculinité toxique est à la base. Une société patriarcale est à la base de ces agissements-là, puis ces comportements-là. Et donc, ça va prendre beaucoup plus que certains filets de sécurité pour réellement enrayer le problème. Donc, merci au ministre. Comme j'ai dit, je me réserve le droit de revenir après avec d'autres questions, mais je vais laisser la place à mes collègues. Merci au ministre, merci à son équipe et merci, Madame la Présidente.
Member from Hamilton-Dalhousie. Oh, okay. Député de Madawaska, Leila-Edmondson.
Merci, Madame la Présidente. Mon collègue s'est pas levé assez vite. On était prêts tous les deux. Et alphabétique, c'est ça, Arsenault. Bon, OK, Madawaska, Leila, ça va. Merci. Et comme plusieurs ont déjà mentionné, effectivement, on ne peut pas être contre la vertu. C'est certainement un projet de loi qui vise à aider à résoudre un problème de société. Et puis, je pense que c'est certainement pas dans la bonne direction, mais comme c'est déjà un bon pas, je veux juste avoir peut-être des réponses à des questions que je me pose comme législateur, mais également comme femme, comme peut-être quelqu'un qui aurait besoin de faire appel à ces services-là. Donc, j'ai quand même quelques questions parce que je me dis, je veux m'assurer aussi que la loi soit appliquée. Je veux m'assurer qu'elle soit là dans les années à venir pour aider les personnes qui en auraient besoin et que ça pourra éviter ou prévenir la violence familiale entre partenaires intimes. Donc, je reviens à ma première question et c'est une des premières, en fait, parce qu'elle est dans le titre du projet de loi. Quelle est la définition de partenaire? Quelle est la définition de partenaire intime?
Okay, thank you for that question, and good question. So you'll notice in the bill that, which I'm sure you already have, which is why you're asking the question, that intimate partner is not defined in the bill. Of course, there was some discussion around that, but at the end of the day, the concern is if we give too much of a specific definition to those two terms, we may box ourselves in as a department, which may in turn lead to the rejection of some what could be legitimate applications. So the reason those words are not defined in the legislation is so that that doesn't happen, because what we don't want to do as a department is be so specific around those terms that someone submits and we say, well, you know, it doesn't fit that specific definition, even though it could be a legitimate application. So we wanted it to be a little bit more open-ended on that sense. Now, it will be tightened up in relation to the policies once we get through royal assent with this bill. Once the regulations are in place and the policies flow from that, the policies will tighten that up so that the department does have, you know, a standardized idea of what they are looking for. But what we really don't want to do is we don't want to reject legitimate applicants because of terminology in a bill. That's kind of the idea behind it. I hope that answers your question.
Merci, Madame la Présidente. Merci, Monsieur le ministre, à travers Madame la Présidente. Oui, ça répond à ma question, mais ça me fait me poser d'autres questions. Par exemple, est-ce que c'est limité à des... est-ce que, par exemple, est-ce qu'il y aura une limite d'âge minimum? Est-ce qu'une adolescente, un adolescent pourrait se prévaloir de ce service-là? Par exemple, est-ce que faut être en âge légal? Est-ce qu'on a besoin d'avoir à ce moment-là l'assentiment des parents? Ça me fait me poser ce genre de questions-là. Est-ce que vous avez des réponses par rapport à l'âge, par exemple, de la part des demandeurs?
Okay, so thank you again for that question. There's no stipulation on age limit in terms of applying for, a risk assessment on an individual. That is open-ended. We don't want to limit that. If we said 18 or over, then what do you happen to do if you have a 17-year-old that's caught in the same situation, right? So, again, the spirit of the bill is to ensure that we don't box ourselves in from denying legitimate applications. So to answer your question directly, there is no age limit. Obviously, if you had a minor apply, I would think the department and law enforcement would try to figure out a little more what's going on there in terms of that application. And maybe have to get parents involved in some form or another. But generally, to answer your question, no, there is no age limit.
À travers Madame la Présidente, merci Monsieur le ministre. Est-ce que c'est possible à ce moment-là que vous parlez de cas de partenaires intimes? Est-ce que ça peut s'appliquer, par exemple, à d'autres situations où des personnes pourraient se trouver en situation possible de risque et demanderaient une évaluation? Et je vais donner l'exemple de participants de sportifs dans des équipes sportives, par exemple. On sait que récemment, il y a eu des cas d'abus et puis ça devient de plus en plus notoire, c'est-à-dire public. Et est-ce que quelqu'un, par exemple, qui est un ou une sportive à l'intérieur d'une équipe, pourrait être quelqu'un qui pourrait être éventuellement un demandeur ou une demanderesse?
Yeah, so thanks again for that question. The intent of the bill is to ensure that people in a relationship, an intimate relationship, have an avenue to get information or at least an assessment, a risk assessment on the person they're in a relationship with. We really didn't want to go down the rabbit hole of coworkers, sports teams, because then we're really, I think it would just get much too complex, and I think it would take away from the real issues of domestic violence. So we really wanted to focus on that. So as a result, this bill would not apply in that relationship, co-worker, sports team, again, unless there is a clear understanding, a reasonable understanding that the two people involved are indeed in an intimate partnership, partner relationship. then it could apply. I'm saying that because I'm not saying we're going to exclude. If you have people that are in a relationship that play on the same sports team, that doesn't exclude them from applying, an applicant from applying. But the intent of this bill is not to say, I have a relationship on a team approach. We play hockey together or baseball together, or I have a coworker. We're not really, that's not the intent of the bill.
Si, Madame la Présidente, Monsieur le Ministre. Donc, relations intimes. Est-ce que vous avez une définition de relation intime, encore là, qui n'est pas dans le projet de loi? Est-ce que c'est des relations intimes, admettons, une soirée, une journée, 2 mois, 6 mois, 1 an? Est-ce qu'il y a une définition sur la qualité, la durée, sur, en fait, quel type de relation intime est-ce qu'on parle dans ce projet de loi ici?
Okay, so again, the idea behind not having those definitions in the legislation is because we were concerned that having it defined in legislation would negate the opportunity for applicants to have a risk assessment done on the individual they want a risk assessment done on. So that's why the definitions are not in the legislation. What will take place is through regulation and then through policy, there is going to have to be a shaping, I agree, a shaping of what it means to be an intimate partner. We have to be careful in terms of timelines, right? Whether that's, as you said, I've been quote-unquote with somebody for 6 months, 6 weeks, 6 days. So we want to strike the balance between ensuring legitimate applications are heard, the assessment's done, the verbal information is given. What we don't want to get into is my neighbor's a jerk and I want to find a way to find out what kind of guy he is. That totally misses the purpose of the bill. So we are going to define that in regulation and policy to ensure that it does deal with intimate partner relationships, and that it's broad enough not to negate those applications, but it's not too broad that now we're getting into all different kinds of problems that could arise from those types of processes, whether it's a neighbor, a coworker, a teammate. It has to be an intimate partner, and indeed that will be defined through regulation and policy.
Merci, Madame la Présidente. Merci, Monsieur le Ministre, pour la réponse. Écoutez, j'ai regardé la liste de ce qui va être défini dans la réglementation. Et j'aimerais savoir, Monsieur le ministre, pourquoi il y a autant d'éléments qui vont être définis dans la réglementation et qui ne sont pas précisés dans la loi.
Thank you for the question. So in terms of regulation, again, the idea behind the legislation is to allow for some flexibility, because we were concerned that if we define it in legislation, then we are indeed boxed in by that legislation for applications that come in. And as a result, you may have some applications that would be rejected. So if we pass this bill and we had those definitions in there, we may find out 3 months down the road, well, that definition is too tight and it's not broad enough to, apply to 15 rejected applicants that we feel are legitimate. At least with the regulation and the policy, it's a living regulation. We can move with that as opposed to regulation. It's easier to change policy, change regulation to ensure that we don't have those rejections of applications that are deemed legitimate. And I guess for best practices, we certainly aren't the only jurisdiction to do this. The UK, matter of fact, most of their premise is all around policy and regulation. It's not necessarily legislation at all over there. They define it within their policies under Clare's Law, which is the birth of where this comes from, as well as Saskatchewan and Alberta. Different jurisdictions do it differently. I'm not saying they don't. But we wanted flexibility. We did not want to be boxed in. And for the reason is we didn't want legitimate applications to be rejected simply because of terminology and legislation.
Merci, Monsieur le ministre, à travers Madame la Présidente. Je comprends assez bien le but derrière ceci, mais est-ce que ça ne laisse pas trop de pouvoir au ministre ou en fait au cabinet de décider si oui ou non, éventuellement, le projet de loi est passé, mais la réglementation va manquer ou de ne pas mettre en application. Moi, ce qui m'inquiète, c'est qu'il y a tellement peu de détails qu'éventuellement, ça pourrait tout simplement ne pas être mis en application et que le projet de loi soit adopté, d'accord, mais qu'éventuellement, par faute de réglementation ou de clarté, qu'on ne mette pas le projet de loi en application. C'est un peu la crainte derrière ça. Je ne dis pas que le ministre n'est pas bien intentionné, puis que son ministère non plus. Je pense que quand on n'a pas suffisamment de détails pour renforcer des lois, il y a des fois où c'est très difficile, justement, qu'elles soient mises en vigueur. C'était un commentaire, Monsieur le ministre, vous pouvez me répondre si vous voulez, mais je vais aller dans la direction de la protection de la vie privée. Et puis, je vais me servir d'un exemple qui, la semaine passée, pardon, j'ai un petit peu de difficulté avec ma gorge, mais la semaine passée, à Tout le monde en parle, c'est une émission québécoise qui est regardée par presque 1 million de personnes. Mais dans les semaines avant, il y avait également eu des articles de journal dans la presse. Et c'est à propos d'un type dont tout le monde connaît le nom, c'est Julien Lacroix, un humoriste québécois qui avait une belle carrière. Et dans le mouvement de MeToo en 2020, a reçu 9 accusations d'agression, certaines fondées, mais certaines non fondées. Puis on a analysé, puis il y a des personnes qui sont revenues la semaine passée à l'émission Tout le monde en parle pour dire jamais j'aurais porté accusation parce que dans une rue, après une soirée bien arrosée, il m'a donné un baiser. Théoriquement, j'aurais jamais dû faire d'accusation ou de demander pour que cette personne-là soit accusée. Monsieur Lacroix, depuis ce temps-là, ne peut pas trouver de travail. Monsieur Lacroix a perdu ses amis, 95% de ses amis. C'est un cas peut-être exagéré, mais c'est quand même des cas réels. Et puis, c'est très documenté. Vous pouvez regarder soit l'émission ou bien les articles de journaux. Mais qu'est-ce qui protège les personnes on dit, bien, il y a des demandeurs qui pensent qu'ils sont à risque, mais qu'est-ce qui va protéger la vie privée de ceux qui pourraient éventuellement se voir accusés ou peut-être se voir blâmés d'être possiblement quelqu'un qui peut causer des risques à la vie de personnes qui demanderaient. Moi, c'est les limites. Puis, on n'a pas demandé d'avis au commissaire à la loi sur la vie privée. On n'a pas demandé d'avis à l'Association des juristes de Law Society of New Brunswick. What are the safeguards for anybody? You know, you can be someone who meets someone, and out of the blues, you know, you can probably get, I don't know, will these people have, est-ce que ces gens-là vont avoir des dossiers judiciaires? Est-ce qu'il faut qu'il y ait un dossier judiciaire pour être considéré comme une personne pouvant causer des risques? J'ai beaucoup de questions par rapport à ça, mais commençons par, c'est quoi les safeguards pour les personnes sur lesquelles on demande un avis?
Thank you. Great question. You know, the other side of the whole Me Too movement is just what you said. There's a lot of people out there that are falsely accused without due process, and you know their name is smeared, and they have significant hardships because of that. So the good news is in this bill, when someone makes an application, when they receive the assessment, or should say before they receive the assessment, there's obligations that that applicant is now under. So in order for them to receive the risk assessment, which again is verbal, there's no documents handed over, and there's no specifics given, okay? It's just a general assessment that that individual faces in a relationship. But Section 14 of the bill clearly defines that that applicant is now bound by non-disclosure agreements. So if an applicant, you know, goes through this process, they get the assessment at the end of the process, the applicant can't then go on Twitter and start, you know, putting that out there. They are bound by this bill that would be a breach of this legislation. So anytime we deal with domestic violence and we deal with this sorts of thing, whether it's privacy, whether it's, as you're saying, you know, the smearing and that sort of thing that can go along with it, but then on the other hand, you want it to be effective, you want it to hold true to what it's intended to do, to give women that opportunity to have the information. There's no question, it's a juggling act to balance those three things. I think this bill has done a good job at doing that. The privacy is protected. The applicant is bound by non-disclosure agreements, but yet the applicant can get enough information to make their own personal choice on what they want to do within their relationship and whatever risk they may choose to stay in or get out of. Valid question. I couldn't agree more, because I hear too of more and more, because of, rightfully so, all of these Me Too movements that are pushing this sort of thing, that there's a lot of individuals now that are trapped in that, and they haven't received that due process. So valid point, but I think this bill does help with that in terms of disclosure section in 14.
Madame la Présidente, merci. Merci au ministre. Puis, en fait, je ne dis pas que le mouvement MeToo n'a pas été utile. Au contraire, il a été très utile. Mais même dans le cas que j'ai mentionné, que j'ai cité, il y a des personnes qui ont accusé pour très peu. Et en fait, la vie d'une personne a été chamboulée à la suite de ça. Mais tout ça dit, comment est-ce que l'information que quelqu'un a demandé un avis sur une personne, est-ce que ça va être inscrit au dossier judiciaire? Est-ce que ça devient un dossier de type juridique, par exemple? Est-ce que ça va être inscrit, je ne sais pas moi, la personne il y a quelqu'un qui a demandé un avis sur cette personne-là à travers le processus que vous suggérez?
Yeah, so the simple answer to that is no. There would be no police file or case file associated with this. Matter of fact, as I said earlier, and the bill is clear on this, that it's a verbal disclosure on risk assessment. There's no documents handed over. So it's in that sense, there's no opportunity for this to go any further than what its intended purpose is, and that's simply to let the applicant know what type of risks they may or may not be facing, and then after that, there's no further action, there's no further reports, there's no further cases or files or anything like that. It's completed at that point.
Le ministre, à travers Madame la Présidente, est-ce que les renseignements soumis verbalement vont être basés sur des dossiers judiciaires ou sur du oui-dire ou des entendus que? J'ai entendu que à travers un tel ou une telle. Est-ce que c'est basé sur des faits, sur des faits concrets qui ont été vérifiés au préalable par des instances juridiques ou des instances policières?
Thank you for that. So the idea behind it is it's a risk assessment that's, so again, I don't want to keep repeating myself in terms of the process, but the application goes JPS. JPS would then go to the police agencies to have the information collected. That information is collected on a local level, provincial level, federal level. Some of the information within that data may include charges, convictions, warnings, anything, but it has to pertain to domestic violence. If someone was convicted or accused of fraud 3 years ago, that's not going to show up here. It has to be surrounded domestic violence and domestic instances. So at that point, it's up then to the assessment team to take all this information that's collected and gather the risk assessment. And, we would have a competent team, of course, that would be able to do that, to be able to look through what's a criminal charge, what's a warning, how many times has the police been called out to this residence for this individual, and there would have to be some fact-based information, obviously, around that, based on that information that's collected by police. But again, I want to be clear, we're not going out in no man's land here with the information. It has to be around domestic violence situations.
Merci beaucoup, Monsieur le ministre. Ma dernière question, je ne m'en rappelle plus. En fait, je veux vous dire que je vais essayer de... Ah oui, bon. Est-ce que lorsque vous allez publier la réglementation, est-ce que vous allez inviter des groupes à commenter et à soumettre des avis sur la réglementation que vous voulez faire adopter?
Okay. Well, that's the first time I've got the question that I haven't gotten yet in relation to the regulatory process. So thank you for that. It gives me a chance to explain it. So once the bill receives royal assent, then again we have to work out the regulation and then the policy under the regulation. So the way it works with regulation, the department would come up with what they would deem would be good regulation to support the legislation. That regulation would be posted publicly for 30 days. Anybody in this chamber, anybody outside the chamber can read the regulation, say, I don't like that, that doesn't make sense, offer some insight, or there's something missing that we think should be added, they can add it. So there will be an avenue by which all of the public, any organization, because the question was asked earlier too about, different organizations that are out there that work with people with domestic violence, they'd have the same opportunity. Provide some feedback, provide some input. Department then, after the 30-day period, would take all this information back, make necessary changes, and then we would have the regulation intact to support the legislation.
Merci, Monsieur le ministre, à travers Madame la Présidente. Écoutez, c'est les questions que j'avais. J'en aurai peut-être d'autres, mais je sais que mon collègue est prêt. Donc, je veux remercier le ministre et son personnel pour avoir répondu, pour la patience que vous avez démontrée pour répondre à mes questions. Merci.
Thank you, Member. I do appreciate that. And again, good questions that are raised. I'm wondering, Madam Chair, could we take just a 5-minute break? And I know there might be some more questions, if there is more questions. Yeah.
We have more questions. We'll take a 5-minute break. Call the committee back to order. I recognize the member from Hamilton Dalhousie.
Thank you, Madam Chair. And I just have a few questions here that, being at the end of the day, at the end of the session, makes it difficult to get the questions, because a lot of them I had have been answered, which is good. So I won't pose them, but it may be some little overlap there, and it can happen, but more for clarification than anything else. And the first area was the area that my colleague started with in the very first questions of the day, and that's what consultations. And I was listening to the answer of the minister, but I just wanted again a clarification on the role of the consultations with First Nations. What was that consultation? Can you explain that to me, please?
Okay, thank you, Minister. Member. Long day. So, yeah, the consultations, they were done. Aboriginal Affairs was included in that. Of course, part of that is the wider, broader Indigenous community. And again, when we talk about regulation, there's opportunity for anyone and everyone to provide input on how the regulations are worded and how the practicalities of this bill will play out and day to day. So, I mean, I'm confident. I've said before, I'll say it again, I'm confident that the consultations that were performed by this department were adequate. And again, that consultation process is not complete because we still have regulations to go through, and anybody can have input on that aspect of it. Thank you.
Through you, Madam Chair, I thank the Minister for his answer. The reason why I'm asking these questions is I am the Indigenous Affairs or Aboriginal Affairs critic, so I've asked this question to other ministers for other bills last spring and specifically. I'll make mention of that again, but could you specifically tell me what you mentioned Indigenous communities that you consulted? Can you tell me who they were, where, or which ones?
So Aboriginal Affairs was consulted. And again, the idea behind that is Aboriginal Affairs has an idea of the Indigenous communities, some of the issues around that. So that was the context of those consultations. Again, regulations coming up. Anybody and everybody can be part of that and provide that input in terms of how the bill plays out on the ground.
Thank you. Just as a follow-up to that, you are probably aware that there's a very poor relationship between the First Nations and the government and Aboriginal Affairs. And the question I asked to the former minister last spring, another minister of another department, answered me basically the same answer. They consulted with Aboriginal Affairs. Well, Aboriginal Affairs are not really represent the Indigenous peoples that reside here in their territory. So again, there's a very poor relationship, and one of the criticisms of it all is that they're not involved in process, especially at the beginning, and especially when it comes to public safety. There's been some accusations there all along, and I'm not saying they're founded or whatever, but there is some evidence of systemic racism, and I think it's important that they be included from the get-go, and should not be just a token talk to the Aboriginal Aboriginal Affairs Department, and that's representing the Aboriginal peoples. And I think it's, I know that the minister, this is probably his first or second bill or third bill, but I would hope that from here on in, that there will be a concerted effort to consult directly with Indigenous peoples that reside in their territory, and we reside in their territory as well. So I think it's important that we do that. The other question I have on consultations is on the Privacy Commissioner. Was the Privacy Commissioner consulted on this bill?
Okay. So, as we talked about privacy, this is probably the 5th time I think I've answered this question. The Privacy Commissioner was not directly consulted, simply because the section in the bill that is referred to in relation to privacy disclosure trumps the Privacy Act, for obvious reasons. If this bill falls under the Privacy Act, then the bill is useless. There's no way for the department to provide any type of risk assessment because they'd be bound by Privacy Act legislation. So the section in this bill does provide protection in relation to privacy, but that does not fall under the Privacy Act. Now, in terms of regulations and policy, I'm sure there'll be some discussions with the Privacy Commissioner by the department to ensure that the regulations policy side of it, is perfectly within the realm of the Privacy Commissioner's mandate, opinion and mandate.
I thank the minister through you, Madam Chair. Just to look at those sections, if we look at the bill, there seems to be a sort of a conflict between the two, and maybe clarification would be needed. I'm not a lawyer or anything, so I would not. But one of the provisions is that if any provision of this Act or the regulations under this Act is inconsistent with or in conflict with the provision of the Right to Information and Protection of Privacy Act, the provisions of this Act or the regulations under this Act prevails, as so the minister just explained. I agree with what he said, and I agree with that's in the, but the next section has to do with the Ombuds's powers and duties not limited. And it says here, for greater certainty, nothing in this Act or the regulations under this Act shall be construed as limiting the powers and duties of the Ombudsman under the Right to Information and Protection of Privacy Act. So I'm just wondering if maybe the minister could clarify those two sections, how they interact with each other, and if they are in conflict or not in conflict. I seem to be getting two messages from that. I'm not a legal-minded person when it comes to those types of statutes, but maybe you could help us with that.
Okay, thank you for the question, and good question. So the idea behind this is, as I said earlier, the section that you had just read, Section 7, Right to Information Privacy Protection, if that was not in this bill, the bill would be useless. It would just completely, as I said earlier, neuter the bill. There'd be no point. So what we wanted to be sure of is that the checks and balances are there despite Section 7. So Section 8 would allow the Ombudsman to ensure that both Section 7 and the Right to Information Privacy Act are both in conjunction with the duties performed under this bill. So the Ombudsman obviously plays a very independent role, the legislative officer. The Ombudsman has the authority to come in and ensure that information collected under the scope of Section 7 is indeed done in good faith and that is protected under that Section 7, despite the Privacy Protection Act as a whole.
I assume, well, Madam Chair, I thank the Minister for that. It seems to make sense, and I just assume that it's been, like, if we would have had some direct consultation with the Privacy Commissioner, I think it would have been useful to be able to say that they've seen this section, they've agreed with it, and or maybe they might have improved it a little bit to make sure, but it's Section 8 still gives the power of the Ombudsman over the Right to Information Act to enforce it, whatever. So whatever he decides or she decides can supersede Section 7, obviously. That's the impression I have with this. That's what those two articles are saying. Now, I'm not, like I said, I'm not an expert, but I would hope that if we're going to pass a bill that it's, you know, it's the right way of doing it, and I know the Minister has indicated that they've looked at other jurisdictions, the UK, Alberta, Saskatchewan, and so I would trust that that's what they've done there, or maybe they don't have the same type of Right to Information Act and things of that nature. I guess every jurisdiction is different, but so certainly that would be something. Did you want to comment on what I just said, or would you prefer I ask a question? Okay. So the question I have is, do the other jurisdictions, like Alberta and Saskatchewan, have a similar clause that covers each area that would cover the right to information? And because they seem to me, they still seem to be in conflict, and I stand to be corrected. Thank you.
Okay. In terms of the other jurisdictions and the section around privacy in Alberta, Saskatchewan, I don't have that information right now, member. We can certainly get it. You know, we can do some research and see how they operate in terms of their privacy legislation. But again, I do just want to reiterate that Section 7 and Section 8 work hand in hand. Section 7 is there to, again, give strength to the bill so that they can actually collect the information. But Section 8 is there to ensure that the Ombudsman still has, you know, the full scope of the Privacy Act to be able to ensure that people's personal information is kept private and confidential. So it's the checks and balances. If we didn't have Section 8 in there, there was some concern that, you know, the Section 7 then neuter the Ombudsman to be able to look at this. So by having the two in, it gives the strength of the bill, but also allows for that independent officer to do his or her job to ensure privacy is protected.
I thank the Minister through you, Madam Chair, and it's something maybe that I'm sure the knowing the minister and his background, he'll probably want a little more information, and we'll probably check on the other jurisdictions. So that's good to see. The other question I have is with regards to the process itself, the application and then the return report and whatever. I'm just wondering, what does the department anticipate would be the time that it would take, the turnaround time to get a report back? Or depending on the situation, would it be an urgent thing, or can you turn it around quicker if you really feel it's a high risk, or is it just a standard? Is it 3 weeks, 4 weeks? And I can't hold it to you. It's what do you anticipate it to be? And I'm sure you have other jurisdictions that are doing the same thing, so you must have an idea. Thank you.
Thank you for that question. So in terms of time, other jurisdictions, it's up to 30 days is generally when from the time of the application to the time of the assessment being disclosed to the applicant is about 30 days. So it's hard to, based on an application, and again, we got to work out how that application would look, the details, what information is put in the application, which may help triage whether this is like an imminent threat. We could possibly look at having those elevated. But generally speaking, there does have to be a process. Again, you've got the application, so the first thing that has to happen when the application comes in is this legitimate? Is this indeed an application in relation to intimate partner situation? Once that is saying, gets the check mark that yes, this is a legitimate application, then you have to go to the law enforcement. They have to collect all that data, which there's some level of time involved in that. Then it's got to come back to the department. The department then has to go through all that data to develop an assessment of risk, and then finally give it back to law enforcement to meet with the applicant to give the verbal risk assessment. So you can see there that there would be time that would need to be allotted. That's why most jurisdictions, again, are up to 30 days, which, frankly, is somewhat problematic. I acknowledge that. Other jurisdictions have acknowledged that, but it is just the reality of collecting that information, doing the assessment. There is some time involved. The good thing with us here is that, again, we're not putting this on the backs of police. As Minister of Public Safety, I'm well aware of the strain on police right now, so we're not going to add to that. That's why we're doing these assessments internally. The bulk of the work will be done by the department. We're just going to need the police to give us the data and then give the assessment once the data is completed.
Okay, thank the Minister through you, Madam Chair. That's a very clear answer, and I appreciate it. The other question with regards to the report going to the applicant, it's a verbal report, as I've heard numerous times today. So am I clear that it's by telephone and no face-to-face? Is that the idea? And so maybe the Minister could answer that question, and I'll pose my second one.
It would be a face-to-face meeting. Again, verbal, no documents exchanged.
So the question would it be the regional office? We're talking about, the province, and someone makes an application maybe from Edmonton or Dalhousie or Hamilton. Would they have to come? Would the officer or the person who's taking care of this case have to travel up there to meet with the client or the applicant, or do the applicants have to travel to Fredericton? And
thank you for the question. So, no, the applicant wouldn't have to travel. It would be a local law enforcement would deliver the information. There may be some sensitivities, I'm sure, around the location where they're meeting with law enforcement, and I'm sure law enforcement would work with them to minimize any sort of apprehension around where that information is delivered. But no, the idea behind this is to make it as easy and simple as possible for the applicant. We don't want them any undue burden of traveling and this sort of thing to get information that they deserve to have.
Thank you, Minister, through the chair, and I appreciate that answer. The next item I have for you is we talked about protecting the privacy of the person that it's being looked at. And I believe my colleague talked a little bit about that. Sometimes there are false accusations or whatever. But one of the things that is clear in the bill is that the person receiving the information cannot use it outside of its purpose, right? The Privacy Act. Is there what happens if they do? Is there such a thing as a penalty? Well, what's to prevent them from doing it? That's what I would like to know.
Okay, so as I stated earlier, look, the idea behind this program is to ensure that the applicant gets the information, accurate information in terms of a risk assessment. There are privacy sections in the bill to protect, to ensure it's not disclosed, non-disclosure clauses. The applicant has to sign a document to ensure nothing is disclosed. The protections are in place. Like anything else, yes, the applicant could go out right to Twitter and blast it all out. But there's going to be consequences because the bill forbids them from doing that. In terms of internal government disclosure, the bill's clear. You can't just disclose this information. So it's no different than any other department. Privacy is held in high regard among government, and you know, government does its best to keep that information secure and private.
Thank you to the Minister, through you, Madam Chair. So there is no real deterrent for a person not to disclose. You know, we talk about these issues. They're very emotional issues, and people do things sometimes when they're emotional. I do that myself, get emotional sometimes. I just say things sometimes I wouldn't want to say, or, you know. But so I want to be clear on this, that there is nothing that prevents a person from using that information in a public domain, except they've signed off that they wouldn't do it, or they've said they wouldn't do it, because there's no real prevention mechanism. There's no, I don't know if there's a penalty for something like that, or I don't know. They can't lose their job. Or if maybe they were working for the provincial government, would they lose their job? You know, would that be a reason to lose your employment? So just want to know that. Thank you.
Okay, thank you, member, for that question. So, again, the bill is clear, and I think we both understand that information is not to be disclosed. The question that you raise is in relation to penalties. Should the applicant go out and disclose that information? There was some discussion about having the penalties in the bill. The concern was we didn't want to scare people away from applying by misunderstanding the penalties in the bill. But I would say that because it is clear in the bill that there are always options for penalties to be imposed upon people that break this legislation, just like any other legislation. I would also say that any applicant who went through this process and disclosed the information could also face civil suits, right? So there's, and again, would have the backing of this bill that would forbid them or prohibit them from disclosing that information. So there will be some penalties. I can't define exactly what they were, and we didn't want to define it in the bill again because we were just concerned that that would cause some women or others to not apply by misinterpreting what the penalty might be within the legislation. But there are ways. At the end of the day, it's clear in the bill. The law will be there. The penalties and the civil suits that come after that would be part of the repercussions for breaking that piece.
Then I would suppose if that is maybe a process in itself, then I would think that there would be some record. It's a verbal report to the person, the applicant, but there would be some record kept with the department on what was said or what was reported, and a file somewhere in the department's public safety or Department of Justice's records somewhere.
Hate to be Captain Obvious here, but yeah, there'd be records. Digital records, paper records, all protected, again, under privacy, non-disclosure.
Well, the reason why I asked that is that there has been, there's been cases in the medical field, at least, where people have accessed medical records that had no reason to access them, either x-rays or medical record for some type of illness, sickness, or reports on people. Is there going to be some technique or something where you can sort of make sure that records are not being accessed by people who have no business accessing them?
Minutes. Okay. Section 16.1, confidential and privileged information. A person shall not disclose any disclosure information that comes to their knowledge under this Act unless the person is authorized under this Act or is otherwise authorized by law to do so. Section 16.2, subject to subsection 3, the name of an applicant and any other information that would identify the applicant as privileged information of the applicant. Section 16.3, information referred to in subsection 2 may be disclosed if the minister so directs.
Well, I thank you. That's pertinent. What my question was basically is, if someone is not authorized, will they be able to get into areas of those files? Like, would all the members of the Department of Public Safety or Justice, anyone can access those files, or will there be a certain contingent not able to access? So I guess they missed a point, but okay, we'll go on to something else. You answered my colleague quite often, a while ago, about definitions, and you didn't want to have definitions in there, but because you wanted more flexibility, and I think that's a good point. The only thing is, you have you're going to tighten those up when it comes to regulations. Well, couldn't we have used the regulations from Alberta and Saskatchewan and the UK and brought out those regulations that we could see them ahead of time and see what we're actually voting on? Or you know, it leaves a lot of power to the cabinet on making up those definitions. And yes, they'll be public. You have a viewing for 30 days, but again, the decision is still with the cabinet or governor and council, whatever the term is. But so that's what happens with some of those items. I don't want to keep this too long because there are some people that have receptions to go to, I guess. They're getting kind of antsy, so I'll go back to, you know, I did wait all day here. I listened all day. I was in the House all day, and I have had my questions prepared, and so I think that I deserve the time that is needed. The other thing is, just a specific question, does this bill, Intimate Partners Bill, apply to same-sex partners?
Well, I suppose if the same-sex partner is an intimate partner, yeah.
I don't, you know, there's no description in here, so I just want to ask that. So, and that's fair. I agree with that wholeheartedly, and you've answered the way I would have appreciated you to answer, I think. The other thing is two things, and just sort of a general comment. I know when the minister was on this side of the House, he believed quite heavily in promoting the use of the Law Amendments Committee to call in witnesses and that. Not on every bill, but on certain ones, and he did speak in support of those things. And I would hope that he would continue to feel that way. And on certain bills, not all of his bills that are coming in, this would have been a good one to have the consultations done through the law amendments. We could have ironed out a lot of these things, and we would have had a chance to listen to the stakeholders. There's that aspect. And the other thing is, I'm just wondering with regards to resources, and we've heard a lot about resources today and the need for more resources. I visited a women's shelter and family shelter not too long ago. In fact, it was in October, and at that time, I was told that their budgets have not really been increased over time, and they need more funding. And I know that doesn't fall into the minister's purview. It's in another department. But he does sit around the table in cabinet, and he could raise it at the cabinet table, and I would feel very badly if I didn't mention that to the minister, that if he has a chance, put in a word that some of these, for these shelters, and most of it has to do with retention of workers. It's a tough job in there. They're well trained. A lot of them are social workers. A lot of them have post-secondary degrees and this and that, and they can get better pay somewhere else most of the time. So, and that happens off and on. So so I'm wondering if when we talk about retention and recruitment in the healthcare industry, well, when it comes to women's shelters, that should be a priority as well. And I would ask the minister to maybe intervene if he can and put in a good word for those shelters that they get their proper funding. I want to end by thanking the minister and his staff. The minister has been very patient, especially at the end of the day with me, because sometimes he thinks I'm just asking these questions, but these are questions that I've had from the beginning of the day, and that I had, and you know, it concerned me. So the minister has been very fair with his clarifications, and I appreciate that. I appreciate the staff as well, because as hard as it is on the minister, the staff has to sit here as well and listen in. But overall, I think it's a step in the right direction, and we'll be supporting it. Thank you.
Thank you, member. And if there's no more questions from the floor, We'll give the last word to the minister.
Thank you, Madam Chair. So, again, I know we're coming to a close here. We've been at this all afternoon. It's a good bill. It's a good bill. Is it going to solve all the world's problems in relation to domestic violence? No, but it will certainly mitigate and prevent a lot of instances from happening, and it gives people tools that they can use to ensure that they're have some feeling of security, that they're in a safe relationship. So I have nothing to add other than to thank my staff here. You know, I think they've done a great job on this, and I know they'll continue to do so to get this through the Royal Assent, to get the regulations in place, the policies in place, so that the program can be implemented and we can help some of these issues in relation to domestic violence. I want to thank again. I know Colette's been here all afternoon supporting this, and the support from the other side of the aisle on this bill too. So it's a good bill. I'm proud of it, and the department did a great job on it, and just looking forward to getting it through. Thank you.
Thank you, Minister, and thank you, staff. I'll ask you to leave now and we can have the vote. Is it the pleasure of the committee that Bill number 17, Disclosure to Protect Against Intimate Partner Violence Act, stand as presented, and that I report the bill as agreed to? All in favor of the motion say yea. Yea. All opposed say nay. Motion carried. And I think that we're done. And seeing as it's close to 6 o'clock, I call the committee adjourned.